I'm getting ready to start the meeting. This is the regular scheduled meeting of the Board of Architectural and Engineering Examiners. Is taking place in Conference Room 1A of the Davy Crockett Tower, 500 James Robinson Parkway, Nashville, Tennessee. And notice of this board meeting was posted on the board's website on August 5th, 2013. So we're this board is called to order. Roll call.
Susan Ballard.
Here.
Wilson Borden.
Here.
Hal Baltrup.
Here.
Robert Campbell.
Yes.
Jerry Headley.
Here.
Philip Lim.
Here.
Bill Lockwood.
Here.
Rick Thompson.
Here.
Where? Frank Waxter.
Here.
Rick Bersai.
Here.
Laura Reinbold. Here. Stephen King. You have a quorum.
Thank you. Acknowledge the guest. I guess if the people in the back would like to introduce themselves, we can wait until later in the meeting. Thank you. Thank you.
I'm going to have to talk to Michael about getting a card about any pound.
Announcements? John?
I do have a few announcements. First of all, Philip Lim and Rick Thompson have been reappointed to the board. I think we announced that Rick had been reappointed previously, but we wanted to mention that just in case we had not. And Laura Reinbold has been appointed as the Middle Tennessee Associate Engineer Member, replacing Alton Heathcote, so wanted to mention that. Additionally, regarding the parking situation, I think that Wilson's mentioned it to some of you already, but you'll need to leave like a note in your windshield, apparently, if you park in those visitor spots, so we'll send out something that you can put in your windshield. Otherwise, they might put a nasty gram on your car windshield, apparently, which we're not aware of. Also, if you got some strange letter from Great West Retirement Services about a 401k plan and making plans for your retirement dreams, you can just ignore that. You received this because you're on the state payroll. You get your $50 per diem for attending this meeting. So anyways, that's why you got that in the mail. You can disregard that notice. Thank you.
Thank you. I guess we have one more guest. Arrive late. Thank you, Candy. I guess review agenda for changes and or additions. Is there anything on the agenda? Do I need a motion for that? Okay. The agenda is accepted. Our next item will be the rulemaking hearing, which is attached. And under your tablet, what
Page 70.
page 70 on your tablet. Now, I guess, would you present that, Robert?
Okay, we're going to have a rulemaking hearing. It's rather lengthy and it requires me to do a lot of reading, so just to follow along. After I'm done reading it, we'll go through the rules as proposed, vote on any changes or amendments that you'd like to adopt into them, and take public comments. So the actual language starts in 72. Rulemaking hearing is called to order. My name is Robert Herndon. I serve as attorney for the Tennessee State Board of Architectural and Engineering Examiners. Would the agency representatives who are present introduce themselves for the record? We'll start with Frank.
Frank Waxter.
Jerry Headley.
Susan Ballard.
Steve King.
Laura Reinbold.
Philip Lim.
Bill Lockwood.
Robert Campbell. Hal Baltrup.
Ricky Birdseye.
Wilson Borden. Rick Thompson.
Scott Cothran.
It's Wednesday, August 14th, 2013. This rulemaking hearing is taking place pursuant to Tennessee Code Annotated Section 45204 in Conference Room 1A of the Davy Crockett Tower, 500 James Robertson Parkway, Nashville, Tennessee. The purpose of this rulemaking hearing is to solicit comments on rules the Board of Architectural and Engineering Examiners is proposing to update certain registration procedures and requirements for registrants, modify the rules of professional conduct, adjust the application of the rules to engineers, and update continuing education requirements. The Board of Architectural and Engineering Examiners is proposing these rule amendments and new enforcement rules because the Board has identified the need to update administrative practices regarding the above in order to better regulate the professions it oversees and to better protect the public health, safety, and welfare. A rule is defined as an agency statement of general applicability that implements or prescribes law or policy or describes the procedures or practice requirements of the agency. Proposed rules are filed with the Office of the Secretary of State, notice is given to the public for comment, and a rulemaking hearing is held. Upon conclusion of the hearing and adoption of the proposed rules, the rules are forwarded to the Attorney General's Office for review of legality. If approved, they are filed with the Secretary of State, which is responsible for publication, and the Government Operations Committee of the General Assembly. The rules must stay in the Secretary of State's office for 90 days, the end of which time will be the effective date. Those members of the public wishing to speak should sign up at the table at the back of the room, and only those who have signed will be permitted to speak. Notice of rulemaking hearing included the entire text of the proposed rules and was filed with the Secretary of State and published on its Administrative Register website on June 21st of 2013. Mr. Cothran, what additional notice was given to the affected individuals or groups?
Notice was published in the board's newsletter, which was distributed to all registrants, building officials, and other interested parties. It was also posted on the board's website.
See, here's public comment on the proposed rules. I, as moderator, reserve the right to limit such comments if they become repetitive. Please limit your comments accordingly. I will read the substance of the proposed rules into the record. Again, we're on page 72. All right. Rule 0120.01.03 residency requirements is repealed. Rule 0120-01.17 postponement of examinations is repealed. Rule 0120-01.19 postponement of examinations for engineering interns is repealed. Rule 0120-01.26 fee for transfer of examination grades is repealed. And then under amendments, Rule 0120-01-.04 applications general is amended by deleting the text of the paragraph 1 in its entirety and substituting instead the following language so that, as amended, the rule in its entirety shall read: Paragraph 1, applications for registration and certification are available on the board website and upon request from the office of the board. Paragraph 2, any application submitted which lacks required information or reflects a failure to meet any requirement will be held in pending status until satisfactorily completed within a reasonable period of time not to exceed 5 years from the date of application. In paragraph 3, any application submitted may be withdrawn, provided, however, that the application fee will not be refunded. Rule 0120-01.05 applications for engineers is amended by deleting the text of paragraph 1 in its entirety and substituting instead the following language so that it is amended. The rule shall read: Paragraph 1, an applicant for registration as an engineer shall submit the application with the application a non-refundable application fee of $30. An applicant who has passed the required examinations shall also pay a biennial registration fee of $140 and shall receive a certificate of registration. Paragraph 2, an applicant for registration as an engineer by COMITEE shall pay a non-refundable application fee of $55, and if approved, a biennial registration fee of $140, and shall receive a certificate of registration. Paragraph 3, the deadline for receipt of applications from candidates who must be examined prior to registration as an engineer should be determined annually by the board after the board receives notification from the NCEES of the dates of the examinations. Rule 0120-01-.06 Applications for Engineer Interns is amended by deleting the text of the rule in its entirety and substituting instead the following language so that it is amended. The rule shall read, an application for certification as an engineer intern shall be accompanied by a non-refundable fee of $15. The application and fee must be submitted each time an applicant sits for the required examination. An applicant shall receive a certificate upon passing the required exam and meeting other legal requirements. Rule 0120-01-.08 Applications for Landscape Architects is amended by deleting Paragraph 3 in its entirety so that amended the rule shall read, basically the first two are as they are. Paragraph 1, an applicant for registration as a landscape architect shall submit with the application a non-refundable application fee of $30. An applicant who has passed the required examination shall also pay a biennial registration fee of $140 and shall receive a certificate of registration. And paragraph 2, an applicant for registration as a landscape architect by COMITEE shall pay a non-refundable application fee of $55 and, if approved, a biennial registration fee of $140 and shall receive a certificate of registration. Rule 0120-01-.09 References is amended by deleting the text of paragraph 1 in its entirety, substituting instead the following language so that it is amended. The rule in its entirety shall read, Paragraph 1, references named in applications for registration must be acquainted with the technical ability of the applicant, but need not be residents of the state of Tennessee. A minimum of 5 references for architect, engineer, and landscape architect applicants shall be submitted. References from relatives will not be considered. No reference will be considered if prepared more than 2 years prior to the date of application. Paragraph 2. 3 such references must be registered architects or engineers with registration and experience in the applicant's field of experience, except, however, that applicants for registration as a landscape architect may use references who are registered engineers, architects, or landscape architects. Paragraph 3. A maximum of 3 references shall be obtained from the employer listed by the applicant. References are required from both the applicant's current employer supervisor and a past employer supervisor, if applicable. Paragraph 4. If a reference reply is uncomplimentary, derogatory, or unfavorable of the applicant may be required to furnish additional references. If subsequent replies are unfavorable, the applicant will be scheduled for an interview with the board for further consideration. Rule 0120-01.10 Education and experience requirements for engineers is amended by deleting the text of the subparagraphs 1F and 1G in their entirety and substituting instead the following language so that it is amended. The rule in its entirety shall read, Paragraph 1, subparagraph A, accredited engineering programs. An engineering curriculum of 4 years or more, which was accredited by the Engineering Accreditation Commission of the Accreditation Board for Engineering and Technology, or its predecessor, at the time of graduation, graduation was not more than 2 academic years prior to accreditation, may be approved by the board as being satisfactory. Subparagraph B, not accredited engineering programs. An engineering curriculum of 4 years or more, which is a non-ABET accredited program, should be referred at the applicant's expense to a person or entity approved by the board and qualified to evaluate equivalency to an ABET accredited engineering program for evaluation and recommendation. If the curriculum for the degree at the time of the applicant's graduation is substantially equivalent to ABET accreditation requirements, the applicant should be reviewed in accordance with the requirements for applicants holding engineering degrees from institutions which do not have ABET accredited engineering programs, in consideration of the factors outlined below. Subparagraph C. In referring applicants holding degrees from non-accredited engineering programs, whether obtained in the United States or otherwise, which are substantially equivalent to degrees from ABET accredited programs, the board may consider the following factors. Subparagraph 1. Evidence of having obtained the statutory minimum acceptable progressive professional experience of a grade and character, which indicates to the board that the applicant may be competent to practice engineering, and subparagraph 2, at least 5 references from individuals having knowledge of the applicant's technical competence as an engineer on projects of a grade and character, which indicates to the board that the applicant may be competent to practice engineering. Subparagraph D. Applicants meeting the above requirements should be reviewed by the board for determination of eligibility for either the fundamentals of engineering examination or the principles and practice of engineering examination, or for registration by committee. Subparagraph E. An engineering technology program, whether 4 or 2 years in length, is not considered by the board to be an acceptable curriculum. Paragraph F. Programs that allow credit for work experience and experiential learning, with the exception of cooperative education programs, or which are not part of an institution that is accredited or recognized as a degree-granting institution of higher learning within a national territory in the United States, or in the United States, are not considered by the board to be acceptable curriculum. Subparagraph G. Engineering degrees from programs accredited by the Canadian Engineering Accreditation Board that were awarded in or after 1980 are considered substantially equivalent and do not require evaluation. And then paragraph 2. In general, progressive experience in the practice of engineering consists of engineering experience which is supervised by a registered professional engineer. The board may grant toward experience requirements for registration as an engineer 1 year of credit for graduation with a master's degree or higher in engineering from an approved curriculum, or up to 1 year of qualified experience obtained in an established cooperative education program, which is carried out within the framework of an approved engineering curriculum and which has been approved by the board. At least 1 year of engineering experience must be completed in the United States. Unless otherwise noted above, an applicant's engineering experience must be obtained after graduation with a qualifying degree and completed by the date of the examination. 120-01.11 Education and experience requirements for architects is amended by adding the following language as a new subparagraph 3D, so that as amended, the rule in its entirety shall read: Number 1, paragraph 1. For purposes of evaluating the education and experience of applicants for examination and registration as an architect, the board will utilize the table of equivalents contained in Appendix A to Circular of Information Number 1, published in July 1983 by the National Council of Architectural Registration Boards, except to the extent that such document conflicts with any applicable statute. Paragraph 2. Accredited architecture programs. An architecture program which was accredited by the National Architectural Accrediting Board at the time of graduation, or graduation was not more than 2 academic years prior to accreditation, may be approved by the board as being satisfactory. For purposes of this paragraph, a state-supported school of architecture approved by the Tennessee Higher Education Commission is deemed to have an accredited curriculum. And then paragraph 3, subparagraph A, non-accredited architecture programs. For purposes of TCA Section 62-2-5012 and 62-2-502B, an architectural curriculum of 4 years or more, which is a non NAAB accredited program shall be referred at the applicant's expense to a person or entity approved by the board and qualified to evaluate equivalency to an NAAB accredited program for evaluation and recommendation. If the curriculum for the degree at the time of the applicant's graduation is equivalent to NAAB accreditation requirements, the application should be reviewed in accordance with the requirements for applicants holding architecture degrees from institutions that not have NAAB accredited architecture programs, consideration of the factors outlined below. Subparagraph B. In reviewing a non-accredited architectural curriculum, the board may approve either an architectural curriculum of not less than 4 years offered by a school of architecture as part of an architectural curriculum toward a NAAB accredited degree or its equivalent. Subparagraph C. In reviewing applicants holding degrees from non-accredited architecture programs, whether obtained in the United States or otherwise, which are substantially equivalent to degrees from NAAB accredited programs, the board may consider the following factors. Paragraph 1. Paragraph 1. Evidence of having obtained the statutory minimum acceptable practical experience in architectural work. And paragraph 2, at least 5 references from individuals having knowledge of the applicant's technical competence as an architect. Subparagraph D, for purposes of this paragraph, an architectural degree from a program accredited by the Canadian Architectural Certification Board, or from a program deemed substantially equivalent by the NAAB is deemed to be equivalent to a degree from an NAAB accredited program. Paragraph 4. For purposes of Tennessee Code Annotated 62-2-5013, an approved architectural-related curriculum is an architectural engineering or architectural engineering technology curriculum accredited by the Accreditation Board for Engineering and Technology. Paragraph 5. Effective December 1, 1984, an applicant for the required examination for registration as an architect must have completed the Intern Architect Development Program of the NCARB prior to registration. Paragraph 6. An applicant for registration by comity shall submit proof acceptable to the board of having obtained the practical experience in architectural work required by Tennessee Code Annotated Sections 62.2501 and 62.2502. Paragraph 7. In general, practical experience in architectural work consists of architectural experience which is supervised by a registered architect and meets the requirements of Tennessee Code Annotated Section 62-2-503. In paragraph 8, applicants meeting the above requirements should be reviewed by the board for determination of eligibility for either the architect registration examination prepared by the National Council of Architectural Registration Boards or for registration by comity. Rule 0120 0-01-.14 Examinations for engineer and engineer intern is amended by deleting paragraph 4 in its entirety, so that it is amended the rule in its entirety shall read. Paragraph 1. The NCEES prepares the examinations administered to candidates for registration as an engineer or certification as an engineer intern. The use of materials, reference books, notes, calculators, or equipment in such examinations should be in accordance with instructions by the NCEES. Paragraph 2. Passing score on both the fundamentals of engineering and the principles and practice of engineering examinations shall be determined by the NCEES and shall be reported as pass or fail. Paragraph 3. A candidate who passes either the fundamentals of engineering examination or the principles and practice of engineering examination may retain credit for passing such examination indefinitely. Rule 0120-01-.20 Re-examination for engineers is amended by deleting paragraph 2 in its entirety, so that is amended the rule in its entirety shall read: the principles and practice of engineering examination is graded as a whole. A candidate for registration as an engineer who fails the examination must retake the examination in its entirety. Rule 0120-01-.21 Re-examination for engineering intern is amended by deleting paragraph 2 in its entirety so that it is amended. The rule in its entirety shall read: the fundamentals of engineering examination is graded as a whole. The candidate for certification as an engineering intern who fails the examination must retake the examination in its entirety. Rule 0120-01-.27 Mailing addresses is amended by changing the title to Notification to the Board and deleting the text of the rule in its entirety, and submitting instead the following language so that as amended the rule in its entirety shall read: the registrant or applicant for registration shall notify the Board in writing within 30 calendar days of any change of name, mailing address, email address, phone number, or change of employment. Chapter 0120-02 Rules of Professional Conduct. Rule 0120-02-.02 Proper Conduct of Practice is amended by deleting the text of paragraph 5 in its entirety and substituting instead the following language so that, as amended, the rule in its entirety shall read: paragraph 1. The registrant shall at all times recognize a primary obligation to protect the safety, health, and welfare of the public in the performance of the registrant's professional duties. Paragraph 2. If the registrant becomes aware of a decision taken by an employer, client, or contractor against the registrant's advice which violates applicable federal, state, or local building laws and regulations or which may affect adversely the safety to the public, the registrant shall: subparagraph A, report the decision to the local building inspector or other public official charged with the enforcement of the applicable federal, state, or local building laws and regulations. Subparagraph B, refuse to consent to the decision, and subparagraph C, in circumstances where the registrant reasonably believes that other such decisions will be taken notwithstanding the registrant's objections, terminate services with reference to the project. Paragraph 3. A registrant possessing knowledge of a violation of TCA Title 62, Chapter 2, or this chapter, shall report such knowledge to the Board in writing and shall cooperate with the Board in furnishing such information or assistance as it may require. Paragraph 4. The registrant shall maintain the continuing education records required by Rule 0120-05-.10 for a period of 4 years and shall furnish such records to the Board for audit verification purposes within 30 days of the Board's request. Paragraph 5. A registrant possessing knowledge of an applicant's qualifications for registration shall cooperate with the applicant and/or the Board by responding appropriately regarding those qualifications when requested to do so. The registrant shall provide timely verification of employment and/or experience earned by an applicant under his or her supervision if there is a reasonable assurance that the facts to be verified are accurate. The registrant shall not knowingly sign any verification document that contains false or misleading information. Paragraph 6. The registrant may not enter into a contract for professional services on any basis other than direct negotiation with any governmental entity that is prohibited by TCA Section 12-4-106A2A for making a selection or awarding a contract on the basis of competitive bids, thereby precluding participation in any system requiring a comparison of compensation. Upon selection, a registrant may state compensation to a prospective client in direct negotiation for architectural, engineering, or landscape architectural services necessary to protect the public health, safety, and welfare have been defined. Rule 0120-02-.05 Conflicts of Interest is amended by deleting paragraph 5 in its entirety and renumbering the subsequent paragraphs so that it is amended. The rule in its entirety shall read: paragraph 1. The registrant shall conscientiously strive to avoid conflicts of interest with his employer or his client but when such conflict is unavoidable, the registrant shall forthwith disclose the circumstances to his employer or client in writing. Paragraph 2, the registrant shall avoid all known conflicts of interest with his employer or client and shall promptly inform his employer or client in writing of any business association, interest, or circumstances which could influence his judgment or the quality of his services. Paragraph 3, the registrant shall not accept compensation, financial or otherwise, for more than one party for services on or pertaining to the same project unless the circumstances are agreed to in writing by all interested parties prior to the acceptance of any such compensation. Paragraph 4, the registrant shall not solicit or accept financial or other valuable considerations from material or equipment suppliers for specifying the products. Paragraph 5, when in public service as a member, advisor, or employee of a governmental body or department, the registrant shall not participate in considerations or actions with respect to services provided by him or his organization in private professional practices. Paragraph 6, the registrant shall not solicit or accept any contract from a governmental body on which he or a principal or officer of his organization serves as a member. Paragraph 7, when acting as the interpreter of construction contract documents and the judge of construction contract performance, the registrant shall render decisions impartially favoring neither party to the construction contract. Rule 0120-02-.07 misconduct is amended by deleting subparagraph 5C in its entirety and renumbering the subsequent subparagraphs so that as amended, the rule in its entirety shall read, Paragraph 1, the registrant shall not knowingly associate with or permit the use of his name or firm name in a business venture by any person or firm which he knows or has reason to believe is engaging in business or professional practice of a fraudulent or dishonest nature. Paragraph 2, the registrant shall not furnish limited services in such a manner as to enable unregistered persons to evade, subparagraph A, federal, state, or local building laws and regulations, including building permit requirements, or, subparagraph B, registration requirements of TCA Title 62, Chapter 2. Paragraph 3, the registrant may not take over, review, revise, or sign or seal drawings or revisions thereof, if such plans are begun by persons not properly registered and qualified, or do any other act to enable either such persons or the project owners directly or indirectly to evade the registration requirements of TCA Title 62, Chapter 2. Paragraph 4, the registrant may not make or promise to make contributions of money for the purpose of securing a commission or influencing the engagement or employment of the registrant for a project. Paragraph 5, a registrant may be deemed by the board to be guilty of misconduct in his professional practice if, subparagraph A, he is pleaded guilty or nolo contendere to or is convicted in a court of competent jurisdiction of a felony or fails to report such action to the board in writing within 60 days of the action. Subparagraph B, his license or certificate of registration to practice architecture, engineering, or landscape architecture in another jurisdiction is revoked, suspended, or voluntarily surrendered as a result of disciplinary proceedings, or he fails to report such action to the board in writing within 60 days of the action. Subparagraph C, he has been delinquent in the payment of professional privilege tax pursuant to TCA Section 67-4-1702 and 67-4-1704. Subparagraph D, he fails to respond to board requests and investigations within 30 days of the mailing of communications unless an earlier response is specified. For subparagraph E, he fails to comply with the lawful order of the board. Rule 0120-02-.08 seals is amended by deleting the text of paragraphs 5 and 6 in their entirety and submitting instead the following language, substituting instead the following language so that as amended the paragraph shall read, Paragraph 5, subparagraph A, no registrant shall affix his seal or signature to sketches, working drawing specifications, or other documents developed by others, not under his responsible charge and not subject to the authority of that registrant in critical professional judgments. And subparagraph B, in circumstances where a registrant can no longer provide services on a project, such as death, retirement, disability, contract termination, etc., the successor registrant may perform work on a set of plans originally prepared by another registrant. If the plans are incomplete or at a stage prior to submittal to a reviewing official, the successor registrant may not seal the set of drawings prepared by the original registrant. Rather, the successor registrant must take all steps necessary to ensure that the drawings are prepared under his or her responsible charge before sealing. If the plans are complete and have been submitted to a reviewing official, the successor registrant may provide and seal addenda sheets or documents and seal changes to the original sheets if revisions are necessary. Paragraph 6, subparagraph A, responsible charge. Plans, specifications, drawings, reports, or other documents will be deemed to have been prepared under the responsible charge of a registrant only when, subparagraph 1, the client requesting preparation of such plans, specifications, drawings, reports, or other documents makes the request directly to the registrant or to the registrant's employee at the time initial client contact is made, so long as the registrant has the right to control and direct the employee in the material details of how the work is to be performed. Subparagraph 2, the registrant supervises and is involved in the preparation of the plans, specifications, drawings, reports, or other documents and has input into and full knowledge of their preparation prior to their completion. Subparagraph 3, the registrant reviews the final plans, specifications, drawings, reports, or other documents, and subparagraph 4, the registrant has the authority to, and does, make any necessary and appropriate changes to the final plans, specifications, drawings, reports, or other documents, and subparagraph 5, contributions of information or pre-drawn detail items or detail units that are incidental to and intended to be integrated into a registrant's technical submissions or from trusted sources, including but not limited to manufacturers, installers, consultants, owners, or contractors, are subject to appropriate review and are then coordinated and integrated into the design by the registrant. Subparagraph B, except as provided by Rule 0120-02-085B, any changes made to the final plans, specifications, drawings, reports, or other documents after final revision and sealing by the registrant are prohibited by any person other than the registrant, including but not limited to owners, clients, contractors, subcontractors, other design professionals, or any of their agents, employees, or assigns. Paragraph C, mere review of work prepared by another person, even if that person is the registrant's employee, does not constitute responsible charge unless the registrant has met the criteria set out above. Paragraph D, the intent of the definition of responsible charge may be met if all provisions of the definition are met using remote, electronic, or other communication means. Chapter 0120-04, Interior Designers. Rule 0120-04-.05, Experience Requirements, is amended by deleting the text of paragraph 4 in its entirety and substituting instead the following language so that as amended the paragraph shall read, Paragraph 4, diversified interior design experience should be demonstrated to the board by the applicant who shall furnish the following. Subparagraph A, an affidavit by the applicant attesting that the applicant has engaged in the practice of interior design for the number of years for which the applicant is claiming experience. And subparagraph B, a minimum of 5 references on forms supplied by the board certifying that the applicant has provided interior design services for the period of experience claimed by the applicant. References from relatives will not be considered. No reference will be considered if prepared more than 2 years prior to the date of application. Paragraph C, 3 such references must be registered interior designers and/or registered architects. In addition, 1 client reference and 1 employer reference are required. The client reference may be substituted for the employer reference if an applicant is self-employed. Paragraph D, if a reference reply is uncomplimentary, derogatory, or unfavorable to the applicant may be required to furnish additional references. If subsequent replies are unfavorable, the applicant will be scheduled for an interview with the board for further consideration. Rule 0120-04-.10, professional conduct, is amended by deleting the text of paragraph 17 in its entirety and substituting instead the following language, so that, as amended, the paragraph shall read. Paragraph 17. Registrant possessing knowledge of an applicant's qualifications for registration shall cooperate with the applicant and/or the board by responding appropriately regarding those qualifications when requested to do so. The registrant shall provide timely verification of employment and/or experience earned by an applicant under his or her supervision if there is a reasonable assurance that the facts to be verified are accurate. The registrant shall not knowingly sign any verification document that contains false or misleading information. New rule, Rule 0120-04.13. Notification to the board is added to Chapter 0120-04 and should read as follows. Paragraph 1. A registrant or applicant for registration shall notify the board in writing within 30 calendar days of any change of name, mailing address, email address, phone number, or change of employment. Chapter 0120-05, Continuing Education, New Rule. Rule 0120-05-.14, Alternative Continuing Professional Development Option for Architects and Registered Interior Designers, is added to Chapter 0120-05 and shall read as follows. Paragraph 1. As an alternative to the requirements of Rule 0120-05-.04 Basic Requirements, a registered architect or registered interior designer may meet the continuing education requirement for renewal by obtaining 12 continuing education hours per calendar year. All 12 continuing education hours must be completed in health, safety, and welfare subjects required in structured educational activities. Continuing education hours may be acquired at any location. Excess continuing education hours may not be credited to a future calendar year. Paragraph 2. For the purposes of this rule, CEH means one continuous instructional hour, 50 to 60 minutes of contact, spent in structured educational activities intended to increase or update the architect's knowledge and competence in health, safety, and welfare subjects. If the provider of the structured educational activity prescribes a customary time for completion of such an activity, then such prescribed time shall, unless the board finds the prescribed time to be unreasonable, be accepted as the architect's time for continuing education hour purposes, irrespective of actual time spent on the activity. Not receive credit for activities less than 1 CEH in duration. Paragraph 3. For purposes of this rule, a structured educational activity is one in which at least 75% of an activity's content and instructional time must be devoted to health, safety, and welfare subjects related to the practice of architecture, including courses of study or other activities under the areas identified as health, safety, and welfare subjects, and provided by qualified individuals or organizations, whether delivered by direct contact or distance learning methods. In paragraph 4, for purposes of this rule, health, safety, and welfare subjects are technical and professional subjects that the board deems appropriate to safeguard the public and that are within the following enumerated areas necessary for the proper evaluation, design, construction, and utilization of buildings and the built environment. Building systems, structural, mechanical, plumbing, communication, security, fire protection. Construction contract administration. Contracts, bidding, contract negotiations. Construction documents, drawings, specifications, delivery methods. Design, urban planning, master planning, building design, site design, interiors, safety and security measures. Environmental, energy efficiency, sustainability, natural resources, natural hazards, hazardous materials, weatherproofing, insulation. Legal, laws, codes, zoning, regulations, standards, life safety, accessibility, ethics, insurance to protect owners and public. Materials and methods, construction systems, products, finishes, furnishings, equipment, pre-design, land use analysis, programming, site selection, site and soils analysis, surveying, and preservation, historic, reuse, adaptation. Okay, now is the comment period. So, any members of the public that have signed in? Do we have a sign sheet? I have one written comment, and I'm going to go ahead and read that into the record first. Dated July 5th, 2013, from Julie Harse, P.E. It says, I'm writing this letter to comment on the proposed rule changes that will be considered at the August 14th, 2013 board meeting. Our comment focuses on the proposed change to Rule 0120-05-.04 regarding only crediting the first 12 PDHs earned in a 12-month calendar year. I believe that the current rule credits individuals for taking classes that last longer than 2 days. Examples would be university courses and the 40-hour OSHA training class. Considering the current difficult economic climate, registered engineers and/or their employers would be discouraged from funding continuing education opportunities that extend beyond 12 PDHs in one class. Additionally, extra work would be created for state regulators to confirm in audits that the continuing education was taken in the appropriate time frame. The engineering licenses are issued for only a 24-month period, and the renewal process begins before the end of the 24-month period. It's unclear what benefit is created by modifying the current rule. Thank you for your time considering the RSP. Board have any response to this particular comment?
Comment?
For your reference, the letter is after the notice.
83.
I don't see that it applies to PEs when it states architects and interior designers. Okay. I'm going to respond to her letter.
I have to make a written response. That's why I'm asking the
Okay.
board how they would like to respond to this. Right. Move on to the people who've come in person. The first one is David Brewer, who's engineer for the city of Springfield. If you'd step up to the podium, please. Okay. Next is Candy Toller.
Representing the American Council of Engineering Companies of Tennessee and the Tennessee Society of Professional Engineers. We have some concerns only about the fact that it appears to be overreaching when you want to know the place of employment and all the other information that you're requesting for registrants. There are not that many registrants who are in responsible charge of a practice in Tennessee. And so knowing where Dave Brewer works or anybody who works at an engineering firm seems to be stretching it a bit. And I don't remember how much information, it's been a long time since I looked at a renewal form, how much information you request or provide on the renewal form. John, could you answer that question?
It includes all of this information. the name, mailing address, email address, phone number, place of employment, mailing address. There's even, I think, there's a place for them to record their fax number as well if they choose to
So,
use that.
so registrants have the opportunity to provide that information to you on their renewal form. And it seems like it's burdensome to request that a change be made within 30 days when an engineer changes jobs. And I have another question about how an engineer could find out what address is on file for him if it's not at a time when he or she has a renewal form in front of him. If you go to the website, you cannot tell, even clicking on the details, the address on file. Only the city and the state are on file. So does somebody have to call you to ask you?
They would. That's for security reasons. Years ago, when you were director, that information was readily available on the
Yes.
website, and it was up until recent years, but there was some problems of security concerns about that, so that was removed. Of course, if they get the license and wallet card, that, of course, shows their full address. So if they
Okay.
have that in their possession, that would tell them what address we have on record for them. But, yeah, otherwise they'd have to call us.
So the license form is a good place to look. We suggest encouraging but not requiring place of employment. You've got you're right now, are you required to do the email address? I know you want at least one email address,
Nobody's required to. Not everybody has
but this
an email.
rule will require them to.
If they have an email, we can't require them to have something that they don't submit something they don't have.
I suggest to you that you can get the information on the renewal form and capture it there if you need to. That's my only comment.
I'll make a comment on that. And I've been reading some of the correspondence. I agree that there's some burdensome part to that, but also we run into a lot of trouble, it seems like, trying to contact some people, not everybody. And they're not real diligent about informing the board of changes of status. And so we send an email out, or we call, or we're having to go look for the business that they were. I mean, and a lot of those things, sometimes the name of the business is the only way that we're able to find out where they are. I mean, it's a shame that
How often does that happen, though?
Well, I hear it's Robert. I just want to be formal.
But we're in a very formal setting
I
right now.
understand that. I know that we hear about it about once a meeting on some level, and I'm not going to tell you all levels, but when we get into some of these discipline issues, it seems like that we're hearing about it. We tried to contact them, we tried to do this, tried to do that, and they've changed this, they've changed that. Now, I may be overstating, the staff can help me a little bit on that, but that's what it seems like to me that we do run into that. And I agree that's a lot of information to have to put down, but
And you give them the opportunity to provide the information when they renew.
Had difficulty in being able to contact them, and then it transitions. Because they had a change of address or whatever, and so I think the intent was all an effort to assist the registrant in helping them have current information in the database so these types of circumstances could not occur or would not occur.
I understand.
So
But the requirement that they give you a change of address is now in the rules. That's not new.
I agree, but most people are with the emails and things that's their, you do a lot of communication now through the electronic media, and I think that's that's certainly part of trying to get to that. I'm trying to agree without being disagreeable.
Frequently, the issue comes up when formal hearings are scheduled and we have to send notices of hearing and charges. It came up just at a recent hearing where we had difficulty finding a valid address for the particular registrant, and it is helpful to have more information rather than less information. In cases of formal hearings, we have to have proof that we made every effort possible to contact the registrant. You have to have proof of service in most cases, or proof that you exhausted all avenues to try to contact the individual. So in disciplinary matters especially, which has already been referenced, it's particularly helpful to have that information.
Again, you encourage them to provide that information on the renewal form.
I also add that the mailing address rule that we currently have, that is sometimes cited as an authority to an administrative law judge when we have, right, Rob, when we have cases in which we have to prove that we exhausted all avenues to contact them. We can cite this particular authority and say that they're required to notify us of any address change. So it is helpful in those cases.
Let me ask this question then. The times that we're talking about, the discipline would only recur at a renewal opportunity. They didn't pay their privilege tax, or is there other times besides the renewal time that there may be in violation?
Violation at any time.
Understand, but that we would send something out that they wouldn't act on.
Oh, correct. Yeah, every 2 years they get a form.
And that's when they wouldn't pay their privilege tax, or they wouldn't pay their fees.
But the privilege tax is an annual tax, so that wouldn't go out at the same time as
that's what I'm trying to understand. So just because it's done on the renewal form, if something happens in the interim, that would cause them to be in violation because they may not get their privilege tax, and would not be able to contact them with that. So that's what I'm trying to see.
John, you're saying if there's a complaint against a registered
We appreciate your consideration.
Thank you, Candy.
Okay, the next thing. We're going to talk. I've passed out this document to everybody. It's not in the iPad. It's the Regulatory Flexibility Act. I'm going to record, and there's some questions on the second page, and there's some suggested answers. After that, we'll discuss any changes that the board might want to make on any of the proposed rules. So if everybody has it, I'll go ahead and read it into the record. You don't have one?
Yes.
Really obvious place on the website. I tried to look, but on my phone it's a little too hard to see that. An obvious place on the front page of your website for click here to make changes to your record.
There's a link to giving information on how to make address changes on the website, but it's towards the bottom of the page. As you know, we have a long page. It's not immediately viewable. You can also click on the online license renewal link and make changes through that avenue, but that hasn't been heavily promoted or advertised for that purpose.
Just making it really obvious would simplify it for registrants also. I know there's a lot of things you want to have up there and obvious.
Hey, I'm going to read this document into the record and then ask the board to discuss the questions on the second page. The Regulatory Flexibility Act, Tennessee Code Annotated Section 4-5-401, etc., requires that as part of the rulemaking process pursuant to Tennessee Code Annotated Section 4-5-201, and so forth, all agencies shall review all proposed rules and the effect that proposed rules have on small businesses. The Act requires that, as part of its analysis, each agency shall prepare an economic impact statement as an addendum to each rule that is deemed to affect small businesses, which shall be published in the Tennessee Administrative Register, filed with the Secretary of State's office, and made available to all interested parties, including the Secretary of State, Attorney General, and the House and Senate Government Operations Committees. You've already did this prior to filing the actual notice. The economic impact statement should include the following: the type or types of small businesses and an identification and estimate of the number of small businesses subject to the proposed rule, the projected reporting, record keeping, and other administrative costs required for compliance with the proposed rule, including the type of professional skills necessary for preparation of the report or record, the statement of the probable effect on impacted small businesses and consumers, a description of any less burdensome, less intrusive, or less costly alternative methods of achieving the purpose and/or objectives of the proposed rule that may exist, and to what extent such alternative means might be less burdensome to small businesses, a comparison of the proposed rule with any federal or state counterparts, an analysis of the effect of the possible exemption of small businesses for any or all or any part of the requirements contained in the proposed rule. Okay, and then a really brief description of the proposed rules. The Tennessee Board of Architectural and Engineering Examiners convened a rulemaking hearing on August 4th, 2013 in order to consider amending current board rules governing registration requirements and procedures, the rules of professional conduct, rules relative to interior designers, and continuing education requirements. These amendments generally concern housekeeping matters and addressing the upcoming conversion of the Fundamentals of Engineering exam to computer-based format. Contained in the notice of rulemaking would replace current relative requirements with the proposed updated standards. All right, here's the questions the board needs to think about. Number one, types and estimated number of small businesses directly affected. And there's a suggested answer in there already, but you don't have to adopt it. These amendments would not impact small businesses because the board licenses individuals, not entities. And if the board wants me to, I'll just go through all of these at once. Prefer me to do that? Okay. Number two, projected reporting, record keeping, and other administrative costs. There are no projected administrative costs as a result of these amendments. Number three, probable effect on small businesses. There is no expected adverse impact on small businesses as a result of these amendments. Number four, less burdensome, intrusive, or costly alternative methods. The board knows of no other alternative method to achieve the goals exhibited by these rules. Number five, comparison with federal and state counterparts. There are no federal counterparts to the issues addressed by these rules. 6. Effect of possible exemption of small businesses. There will be no exemptions created by these rules because we don't license businesses. And then the last sort of statement down here is impact on local governments. The Board of Architectural and Engineering Examiners licenses only individuals and foresees no financial impact on any local governments. Okay, these are the answers presented for the board's consideration. If you'd like to make any changes to these, or the board can vote to accept these answers.
Any discussion? Second.
And before we move on that, we have one more comment.
one question related to whether there were alternatives, and there is an alternative, and that is on the renewal form. Rob's answer was there's no other alternative.
Who was requiring to notify the board of any change? I guess that would be a method of compliance. Methods, but the requirement is the same.
We have a motion and a second. Any other discussion? All for the motion. All in favor?
Aye.
Opposed?
That's the thing we need to do is to think about the proposed rules and see if the board would like to make any amendments to them.
I'd like to make a comment on one of them. Under the continuing education, it's 012006-05-.14, item 2. That particular paragraph refers to architects only, and the rest of what I'm reading there, it's architects and interior design.
I noted that too, not only in that paragraph, but in the third one. It references health, safety, welfare subjects related to the practice of architecture, so that should add interior design as well. The reason that happened is because we tacked interior designers onto the rule later and didn't notice that architecture was referenced elsewhere in the rules.
Does that need to change in the rules?
Vote needs to vote to make that change.
Motion?
Move that the paragraphs under continuing education where the architecture is specifically noted, it should read architecture and interior design.
A second.
Have a motion and a second. Any other comment? All in favor, say aye.
Aye.
Opposed? The motion carries. To make the change.
Are there any other changes that the board would like to consider to these proposed rules?
Page 9, the language is gender specific rather than function specific, and on page 12 as well. I understand these are amendments to existing rules, but what's the rationale behind that?
Well, just in the past, it's just been sort of generic to indicate the registrant. I mean, we could go back and put the registrant or registrant instead of any gender specifics. It would be a little...
The rest of the document is registrant or applicant.
So replace his or he with registrant wherever it appears.
Registrant or applicant, I think there are two different. And then on page 11, under the interior designer, paragraph 17, it's his or her, which I think also should be function specific, not gender.
Hey, let's take, was it page 7 was the first one?
I think that appears throughout all the rules. There's some inconsistencies like that, which that may be something that might be better to hold off to a rulemaking hearing maybe next year to do housekeeping. I'm pretty sure if we make those changes to these, there's going to be several other instances and rules that are not being amended at this time. So maybe to be consistent, that maybe should be part of a future.
I'm sure it's true, but why not go ahead and do it now?
Well,
What would be the harm on the ones that are open? And then maybe next year finish the housekeeping.
Right.
To make sure we're consistent. Yeah.
So was it?
Require a motion to do that?
Yeah, let's take a look at the rules that are
I make
impacted.
a motion to remove the gender-specific references in the
Take a look at the specific ones that are being referenced. So, is this?
By the page number.
Why can't you just do it general instead of doing that? Can we not do that?
Is there a reason to ever use a gender-specific reference?
It's just that's the way it existed prior to any rulemaking. That's the way they were originally written. is the only answer I could really offer.
You have an opportunity now to change that.
I think we should.
Okay.
So, do we need to
That's-
reference each one specifically,
Yes.
or can we do instead of generally?
I would like to make sure that each rule that we change is voted on.
All on page 9. I looked at it while he was reading.
Okay, so let's
Yeah.
take a look.
9 and 11 is the his and her. Yeah, I'm not betting the house on that, but I'm pretty sure that that's where they were. It's all under those specific.
If
there
we
was-
make them specific, Rob, and there are others that we just haven't recognized during this review, haven't accomplished the objective. I mean, can we not just say, the motion state that any gender-specific reference to applicant as appropriate?
That's kind of what I was getting at. It could be either registrant or applicant.
Right. But the board office you have the knowledge to know which is applicable, correct? That to your discretion in the motion. What's the problem with doing it that way? All right, page 9.
Starts with 1. Starts
Starts
with
with
Article
1.
1.
Rule number,
That's going to be the problem. Okay, Article 1, page 9. Any reference on page 9 that is gender specific, the motion is to change it to applicant or registrant as appropriate in the context of its reference.
All of page 9 is registrant. Is that true?
See, I don't. Be substituted with the term registrant or applicant as a
Another way you can do a phrase your motion is that it was presented in here that in each article, when in each particular article that you have the gender specific, to change it to registrant or applicant, and then read through this list, whole list of all this into his record. That's one way to do it. That's what I'm thinking. Be quicker.
I think it's the same thing you just said.
Basically, read into section
Sounds
by
better
section.
that way. Make the motion. Let's go for it.
Don't wait for attorney to come back.
No, I don't think so. This is done during the hearing.
Mr. Chairman, there are other references. There is one on page 10 where it just says he.
I missed one.
I mean, I think there are a number of places in here where
We're
we
going to have that the document in its entirety. Thank you.
Thought today's notice was long in the reading of it. Yeah, that rule making is probably really long because it's just about every rule, I think.
okay,
It'll take a long time.
let's just make a general motion as Hal recommended, that wherever gender specific identifications appear in these open chapters, that they'll be changed to either registrant or applicant, whichever is appropriate.
This open record today.
The one that's the chapters that are open.
Take that motion?
Yes. Yeah.
Motion to substitute any gender-specific reference in the open rules as of August 14th, 2013, and substitute those references for registrant or applicant as appropriate or applicable to the context of the rule in question.
I have a second.
Second, that.
I have a motion and a second. Any further discussion?
Question. Once this is passed, then somebody was recommending that we go back next year and finish going through this process so the entire statute corrects all of that.
We have 5 chapters of rules. We're only opening little parts of certain chapters. But we can't change things that haven't been opened in this notice. So we can affect it in these rules today.
But, Jerome, I thought we have a law and rule committee that probably will look into this for us. And
Rick is the chair.
Rick, you know there? He's not there. So when he's not here, we just give him that sign.
That's right. We'll make that assignment to him.
I think it'll be a,
I'm here. I just had it on mute so I wouldn't bother anybody.
we're saying, Rick, what we're saying that Jerome was suggesting that we need to go back and relook at the entirety of the document that we have in the law and rule. My suggestion is to send it back to the committee, which you are chairing, the law and rule committee, to look at it. Anywhere we find gender specific, we might want to kind of bring it back to correct it. I'm sure we'll be in our law and rules making.
I agree with Rob in that that should probably be something we take up as a separate item and not something today, because it's going to take a lot of work to go through that and discover all those gender specific references.
Okay. Any further discussion? All in favor?
Aye.
All opposed?
No.
The motion carries.
So the motion that passed is that in these rules that are open, it changes to applicant or registrant. We have to go back in the non-open parts later. And Mr. Campbell votes no. Okay, any other further?
I have one kind of issue, I guess you'd say, is on page 4, where it's referring to references supplied by applicants. I've reviewed lately a few applications for exam from people that have graduated within a year or so, and they do not have the experience, technical or otherwise, to submit the references that are required here. In other words, this is asking for 5 references shall be submitted, it says, and then 3 of those should be from registered architects or engineers. And pretty much, from what I understand, because I rejected one of them because they didn't have the references, but from what I understand, if you don't have them, you can't supply them. But this is seeming to require it. So
you're talking about exam applicants?
Yes.
Who are applying to sit for the ARE before completing their experience?
Right.
In those cases, because the rule doesn't address when those references are submitted, in our application instructions, it informs them that the references can be submitted following completion of IDP, their experience. After they've passed the exams, they can submit those references, since the rule doesn't specifically address when they're submitted. And then we don't actually register them until those references have been submitted to us. But that's the way we instruct the applicants in those cases, if they're applying before they've completed their experience. Now, same thing for landscape architect candidates as well, that they can submit their references after they've completed their experience. So
in that case, the process would be, you take the exam, you pass it, let's say, and in 2 to 3 years, you have the experience required. Then they submit these references. They are reviewed by your office. Okay.
Something derogatory, of course, then it would go to you.
That couldn't happen.
Never happens. No.
What other actions do you need? Do you need to
Any other proposed amendments?
changes or amendments?
How's the time?
Consider the burdensome nature of the 30-day tested time frame or alternative, or just to consider eliminating the 30-day requirement, Candy?
60 days would be good, but our suggestion was removing the place of employment requirement.
Stay up there just a second. Wait a minute.
Is on the renewal, and I'm trying to recall, and I apologize as well that I'm not clear, but are those required fields? As long as you have a mailing address, it doesn't have to be your place office box or
Right.
whatever. So does that have a bearing, Candy, on your agents?
Is it the amount of info? And again, I read the emails, and I'm trying to put this in perspective, because to me it doesn't seem burdensome for the information. Is it more burdensome or is it intrusive?
Intrusive.
Okay. Because if I get a business card made up, I can scan that and send it to the board office and have all that information done in 2 seconds. I mean,
If they can accept it in that format.
Or your but I mean, your members or your representative or your constituents or whatever, however we reference them, they're not opposed to. I mean, they have to have an address on record.
But the address is already in the rules.
Right.
That's not new.
So, but
the
if their
30
address,
days is in the rules.
if the address changes though between renewal periods, are you
You
saying?
need to know their a mailing address.
Okay.
I'm not quibbling about that.
Okay. So the issue is requiring the business address.
Requiring an employer, the name of an employer.
I mean, does that have a bearing on the processes of the board office as we can sit here?
It's helpful to have 2 addresses for them, so we have one to fall back on if one's undeliverable. But
Okay, if
it's not something that we have to have.
so, but both are not required for renewal, are they? Okay, and is place of employment required for renewal? Okay, so having said that, or explain that being explained, does that alleviate your concern? Okay. 30-day reference is for what specifically, John?
What is a 30-day reference?
What's the requirement of the registrant to do within the 30-day period?
Currently, just to notify us of a change in mailing address. This would change that to a change of name, mailing address, email address, phone number, or change of employment. Most of the language was borrowed from, I think, an accountancy board rule when we originally drafted this. I think phone number, if I remember, was added later. So it's pretty consistent with what
Standard,
some
sure.
other professional boards require.
Understand. Let me ask though again. Place of employment incumbent upon the registrant's eligibility for.
No.
We make it optional.
yeah, I think so. I think that's the way I would, because I don't see it as burdensome. I mean, really, because again, I've just said
Intrusive.
intrusive, but also see it is if we get the email, the address, and a phone number, we do have 3 ways potentially to communicate with somebody, and I would think that would be a good deal. But I don't know why anybody would want somebody to know who they're working for. I mean,
And they can still provide that on the renewal form.
Yeah, but that
You know,
just
it's
kinda-
not like
yeah.
you're not asking for it.
So for the 30-day turnaround, again.
No, if you'd make that 60 days, that'd be great
well,
too. But
I don't mean to be repetitive, but I'm slow some days. So if this was modified to eliminate or make optional the place of employment, even in the 30-day window, Is your organization still going to exception to that? If it's
That would
optional?
make it more palatable.
Okay.
But it's already optional on the renewal form, so it's,
Motion to modify the language to make the requirement of business, place of employment notification optional for the 30-day advertisement period.
Where is that?
Would somebody help me understand where in these documents that we've been discussing here, is there something about place of employment or something?
page 11.
Page 11.
And page 7.
7
Oh, in
and
page
11.
7,
Two places, yeah.
Okay, what number or something?
Sort of the middle of page 7, Rule 0120, 01.27 mailing addresses. It's changing that title to notification to the board and then added the language that we've been doing the same thing for interior designers. And that's on page 11.
That's on 11, okay.
Motion, as I presented, changes that.
Speaking to the microphone.
Speaking to the microphone.
The motion on the table right now makes reference to the modification of the language to make the change of employment requirement optional. So within 30 days, the register applicant shall, it's not may, it is shall, it's required that they notify the board of any change of name, mailing address, email address, phone number, and then the new or the motion or change, optionally change of employment, or however that needs to be worded.
Or how about just change it to email address or phone number, and phone number, or, well, it says or.
A change of
Period.
employment? Okay.
Yeah, or phone number, period.
Well,
and then say, registrants are also, like, requested to notify us of a change of employment, or encouraged, yeah.
We're going through all of this because somebody doesn't want to tell us where they're employed. Y'all got to be kidding me. Come on. Candy, this is, I mean, really, what difference does it make?
Well, the number of times you're talking about having a problem with it is 1% of the registrants. So we're not talking, I mean, you know, it's so few. You have 12,000 registered engineers, and Robert says you get one a meeting, so that's maximum of 12 a year.
particularly depending on where so even within a 2-year period, people have changed more than one time. So
In the last 5 years, they've changed a lot.
they haven't changed a lot in the last 5 years. So to Candy's point, the issue is a small percentage anyway, but her membership is asking for relief from the requirement of place of employment because, as John has stated, John Cothran, there is no real business need by the board office to have the information of a registrant's place of employment. The rule change and still allow the board office to conduct business as they need to, as efficiently as possible, and to meet the representation of a majority of our registrants. I think this consideration is just.
You're already in this
Talking
new
like a
rule.
true engineer.
You're getting
It is.
in
Call the motion.
That was the motion. Do I have a second?
That was
We'll
not the motion.
Probably need to make sure we've got the wording exactly
Okay.
the way we want it. Okay, so you're wanting to amend it to read, a registrant or applicant for registration shall notify the board in writing within 30 calendar days of any change of name, mailing address, email address, or phone number. Registrants and applicants are encouraged to notify the board of a change of employment.
I have a second.
Second.
Okay, now, before we vote, we need to do this by roll call.
I can second.
You can second, but before everybody says aye, I just wanted to get that in there.
Then we're moving, we're having a motion and a second to change rule number 012001.27 as stated read into the record by John.
And Rule 012004.10. I'm sorry, point 13.
So therefore, we need to have a roll call.
Ballard,
Yes.
Hal Balthrop, Wilson Borden,
Yes.
Robert Campbell,
Aye.
Jerry Headley,
Yes.
Yes.
Lockwood,
Yes.
Rick Thompson,
Yes.
Frank Waxter,
Yes.
Okay. Okay. We're going to have to backtrack. I'm advised we need to take roll call votes on all motions made relative to the rules. So on the gender-specific motion that we made that was voted on, if we can reread that motion and then do a roll call vote.
I believe Mr. Balthrop made that motion. What was your specific wording?
Modification. I'm sorry. Make sure it's the rules that are open for modification as of August 14th, 2013. Any gender-specific reference herein will now be substituted with the terms registrant or applicant as appropriate in the context of the rule.
So moved.
The second needs to. Okay.
Rick.
Okay.
Right, roll call.
Susan Ballard,
Yes.
Hal Balthrop, Wilson Borden,
Yes.
Robert Campbell,
No.
Jerry Headley,
Yes.
Philip Lim,
Yes.
Bill Lockwood,
Yes.
Rick Thompson,
Yes.
Frank Waxter,
Yes.
All right. We're almost there. Now we have to backtrack to the economic impact that you all accepted. Let's just do a roll call on that one. Motion to accept the Regulatory Flexibility Act Economic Impact Statement.
We've already got a motion and a second, don't we? Can't we just do a roll call?
Ed.
Susan Ballard,
Yes.
Hal Balthrop, Wilson Borden,
Yes.
Jerry Headley,
Yes.
Philip Lim,
Yes.
Lockwood,
Yes.
Rick Thompson,
Yes.
Frank Waxter.
Yes.
Did I leave someone out? Robert Campbell,
Yes. I'm thinking about voting no, just for the heck of it. As I'm left out. Yes.
Okay, two more things. Mr. Wagster discovered that we needed to make a couple of minor changes to the continuing education. And I think that was unanimously voted on too. Let's get a roll call vote on that, please.
Ballard,
Yes.
Hal Balthrop,
Yes.
Wilson Borden,
Yes.
Robert Campbell,
Yes.
Jerry Headley,
Yes.
Philip Lim,
Yes.
Bill Lockwood,
Yes.
Rick Thompson,
Yes.
Frank Waxter.
Yes.
The motion carries.
Now, if there's no further changes to the rules, we vote to accept the rules as amended. And that will be our final action, unless there's other amendments that the board would prefer to make.
Do I have a motion?
So moved.
Second? Do I have a second?
Second.
We have a motion and a second to accept the rules as amended.
Ballard,
Yes.
Hal Balthrop,
Wilson Borden,
Yes.
Robert Campbell,
Aye.
Jerry Headley,
Yes.
Philip Lim,
Yes.
Bill Lockwood,
Yes.
Rick Thompson,
Yes.
Frank Wagster.
Yes.
Motion carries.
No further comments on the rules. This concludes this rulemaking hearing.
Let's take a 5-minute break. Everybody be back in here.
Hey, John.
Yes.
Rick. Hey, I'm going to have to leave in a little bit because of my family commitment. Is there anything you need from me on that legal hearing?
Yeah, there is one that you.
We're going to try to make a little bit of adjustment on the agenda. We're going to move the legal case report up so Rick Thompson can go ahead and make some comments on one of the items that he was reporting on. So, Robert, what page are these on?
Oh,
It's 92.
number 92. Yep. Okay. The first heading is cases with updated information, number 1. It's case 2013-001961. This matter was previously presented at the board's February 13th meeting as follows, and it says the complaint alleges the respondent, a registered architect, failed to keep privilege taxes up to date for the last 3 years. Despite being notified by the board staff, 2 years delinquency can result in suspension and 3 years revocation. At that time, the board approved a recommendation to authorize a consent order, a formal hearing, and a consent order to suspend registration till all delinquency privilege taxes are proven to be current. The update is the board records indicate that since this action was approved, the respondent has deceased. So I recommend dismiss the case due to lack of disciplinary grounds.
Motion, please.
Move.
Second? Somebody?
Aye.
Any other discussion? Vote, please. All in favor?
Aye.
Opposed?
Okay, number 2, 2013-002061. This matter is previously presented as the board's February 13th meeting. The complaint alleges the respondent, a registered engineer, failed to keep privilege taxes up to date for the last 3 years, despite being notified by the board staff. The same sanctions apply to this person. At that time, the board approved a recommendation to authorize a formal hearing with authority to settle with a consent order to suspend registration till all delinquent privilege taxes are proven to be current. The update here is board records indicate that since this action was approved, the respondent has expired, is now beyond the renewal deadline. The respondent will have to reapply to obtain an engineering license. So I recommend close the case for disciplinary purposes. The delinquency will be addressed if any attempt to apply is made.
Question?
The respondent hasn't expired, has he? His license has?
Last respondent expired. This person's license expired.
The way it read is that he's gone.
What says the respondent has expired?
Well, if you'll notice, I use he deceased. Ceased to exist.
If this is case name, I'm reading the wrong one.
Oh, you're right.
Number 2, you're right.
Just a typographical.
The license has expired. Okay, something has expired, not the respondent.
Do I have a motion on this matter?
I so move.
Do I have a second?
Second.
All in favor, please signify by aye.
Aye.
Opposed? Motion carries.
2013-009571. This matter was presented at the board's June 12th meeting. And this complaint alleges the respondent, a registered engineer, failed to keep privilege taxes up for the last 3 years, despite being notified by the board staff. At that time, the board approved a recommendation to authorize a formal hearing and a consent order to suspend registration until all taxes are paid. The board has since been notified by the appropriate department that the respondent has brought all delinquencies current. So standard is to close the case with the letter of warning.
I have a motion.
So move.
Second.
Second.
All in favor?
Aye.
Opposed? Motion carries.
Okay, moving on to the next heading, cases under board member review. Number 4, 2013-011721. The complaint alleges the respondent, a registered architect, committed misconduct by providing a fixed amount in a bid proposal for a local public project under the jurisdiction of the school authority in violation of the appropriate rule, which forbids contracts to be awarded based solely on primary or competitive bids. The written reply from the respondent explains his comprehension of the applicable administrative rule and belief that the submitted documentation complied with it. The complaint materials were forwarded to Architect Board member Mr. Thompson for review to determine if any probable cause existed for possible discipline. So I recommend adopt Mr. Thompson's recommendation based on his analysis of the details of the matter. Okay, Rick?
Okay. This was a school board, and they had sent out an RFQ, and there were several firms that responded to it, and actually my firm was one of those firms that responded to it. And as you went through the request, there was one question that was specific in that it asked how would you propose to be compensated. Typically on education-type projects, if there's state or city or county, some type of municipal, we utilize the state building sliding scale. I put that scale in there as an example of how we would, depending on the cost of the project, how the fee would move in percentage points, either up or down, as an example. And several of the ones that I reviewed, there were 6, I believe. Was that right, Rob?
Something like that. I don't remember specifically. I think it was 6.
Well, of
several
of the 6 that were the finalists that I reviewed, this one firm put in a construction number, a historic construction number that had been used previously on an elementary school, and then he assigned a percentage to that fee and quoted a fee based on 3%. That was his fee, 3%, and it was there was a construction number and a fee quote in his proposal. The company that subsequently was awarded the project, they quoted chapter and verse out of the rule change and the law, and put it in there and said they were forbidden to make a fee quote, and the other ones were vague in that they would do it either on a fixed fee or a percentage basis based on being selected, and they would negotiate that at that point. So of the 6 I reviewed, the one that's in question actually quoted a fee, and I don't know how his response letter justifies what he did. I think in his mind he may think he's justified, but based on the rule change, it's in my mind it's clearly a violation, and whether or not it's a minor infraction and deserves some type of a letter or something like that, I think that's for the board to choose.
Rick, this Wilson, the person in question quoted 3% of whatever the construction budget turned out to be, or something.
Yes,
they didn't know at that time, right?
Well, he didn't know what their particular budget was, but this particular individual does a lot of school projects, and he's got the historic data to tell him what a 700 student elementary school basically is going to cost. So he had historic data. We've all got historic data, but he used a very specific number, and then gave them a fee quote based on that number of 3%.
What is your recommendation, Rick?
Well, at the very least, and I don't have my information in front of me, but in the letters, what are the letters that's in the back of the folder you've got there? Remind me of what they are, please.
The types of letters?
Yes.
We have a letter of instruction, which we use for people that don't have enough experience to know better, and whatever mistake they made was not particularly critical. Then we have a letter of caution, which is sort of applies to some types of recklessness, but didn't really. They should have known better. They could have done it better. Then there's a letter of warning, which tends to go toward we suspect that you've done something you shouldn't have done, and then from there we go into formal discipline, where we assess penalties or in some other way affect the license.
Well, this is a little more complicated too, in that John and the board has asked me to write an article about this, and we recently received a complaint from another architect about another municipality. John, can I talk about that?
Yes, you can.
Okay. From Hamlin County, for a correction center, renovation of an existing correction center, and they were very specific in their language that they were asking for fee quotes, and we talked about it, and John wrote a letter on our behalf as the board, reminding them that was a clear violation of the rules and the state law, which they responded, well, we won't hold it against them if they don't quote a fee. Well, this is kind of setting a precedent on what we do moving forward. If I don't know if we'll ever be able to see those RFPs, RFQs, but they certainly should be aware that if they go forward and quote a fee, that there could be some ramifications, and there should be some ramifications. My recommendation, at a minimum, would be to issue a letter of warning to this architect. Now, it's up to the board's decision and your discussion if you feel like fines are appropriate or not.
Other comments?
Need a second?
Yeah, I'll need a second.
I second today.
Any other discussion?
We do have, before the motion passed, would you be willing to ask, Rick, would you be willing to ask them to take our law and rule and pass our test?
I certainly will. I think that should be part of the motion. I'll amend my motion, and my motion is to issue a letter of warning to this individual and require him to take and pass the law and rules exam.
My motion is still second. Thank you.
Any other comments or discussion?
I have a question. It appears that the firm or the person that we're talking about believes that if he interprets what we have now correctly, that what he did was fine. Is that, Rick? Is that?
That's the way I read it. He didn't seem to have any remorse. So that's why my motion at a very minimum is a letter of warning.
I kind of think it needs to have a fine attached to it myself.
Well, that's why we're having this discussion. What would you suggest?
And if he
Frank?
he hadn't gotten the message.
Well, John, just from your opinion from the letter, do you agree with my take on that he doesn't think he's done anything wrong?
Yes.
He stated he believed that it was what he did was in compliance.
which it clearly wasn't if you look at his proposal.
The other thing that you brought up, Rick, was, apparently at least 5 other firms submitted proposals, and they all got it. This guy didn't.
Yeah.
It's like,
and the one firm that got selected literally had 2 pages out of the rules and the law stating it was clearly against the law to do that, and that they could not do it. I was very impressed with that one.
and the other thing that concerns me is, and you and I both know this happens all the time, but going forward, if we don't support our rules, everybody's going to go, well, I got the job, and I got my letter of warning, and I got a job with a $500,000, $1 million fee on it.
Yeah, I don't disagree with you. That's why I brought that up about that Hamlin County thing. I will entertain a friendly amendment to the motion if you so care to.
And I'm not as familiar with as I guess everybody else is here on what a reasonable fine would be, but I was thinking at a minimum $500.
I think that would be appropriate.
So I would propose to amend your motion to include a fine of $500.
Rick, why don't you make that amendment to your motion?
Okay. All right.
That'd be
I will make a friendly amendment to my motion.
You make a suggestion on how to make that?
Yes.
I'd suggest that you recommend authorize a formal hearing with authority to settle with the consent order. That way we don't have to come back and get approval for a formal later.
Okay. So how would you like me to state that? Just.
So I need to rescind that first motion.
Yeah, I'll rescind my motion, and Philip, you will.
Yeah, I'll second you. Yeah.
That motion's rescinded.
Right.
Make a new motion.
And the new motion, do I restate that, Rob, and then give you the authority to?
Your motion would be authorize a formal hearing with authority to settle with the consent order for $500 civil penalty and requirement to take and pass the law and rule exam.
Okay, I would support the verbiage that you just discussed with us, and that would be my motion.
Second.
Second.
Any other discussion?
I want to just say one thing on this. I was okay with the letter of caution. I'll probably be voting against the motion because it's got the fine attached to it. It sounds like even though this guy really believes he did not do anything wrong, and it's, again, our job to determine if he did or did not, but I'm not sure this is the right case to be making our case on this provision of the of our new law. I mean, that's just my opinion. And Rick, I appreciate what you've done on that, and I can understand where you're coming from. But it's still $500 is not. If you're wanting to make a case, we need to find one that's, to me, a little bit more blatant and really make the case so that it sends the message to them. And I think they can now go by and say, I can get a $500,000 fee job for a letter of caution and a $500 penalty, and I'm not sure that still sends any kind of real clear message to them. So,
Any other comments? All in favor of the motion? Say aye.
Aye.
Opposed?
No.
The motion carries.
Robert, I appreciate your comment, and I don't disagree. But my only sidebar comment to that was the next ones will, if we don't send some kind of signal out there that we're serious, then you're right. They'll think, well, I can just get $500. Well, the next time we won't be so nice.
Next.
Thank you. I'm going to have to excuse myself from the meeting. It's been nice listening to everybody today. All right.
Thank you.
Thank you.
See you
Signing
in
off.
October.
All right. Yeah, I'll be there. Thanks again. See you.
Rob and John, let me, and just one, this is in general. This to me this case, when you decide who reviews these, I would prefer that you have somebody that's not part of the game reviewing this. I mean, Rick was one of the applicants or one of the proposers on this project, and to me, even though I think trust me, I think he's done everything exactly, but I think it puts us in a bad position of having to review against some people that we're competing against if our name happens to be in the hat for that. So I would discourage that assignment of project in the future cases. I'm sorry, yes, sir. So that's my only comment to that.
Okay. Next.
Okay, number 5, 2013-013141. The complaint alleges a respondent, a registered engineer, committed misconduct by improperly preparing an inspection report in possible violation of the appropriate rules. A written reply from the respondent relates his belief that his work was in compliance. There's no complaint history for this respondent. The complaint materials were forwarded to engineer member Mr. Bursai for review to determine if any probable cause existed for possible discipline. The allegation is incompetence, but that's what the allegation was.
Yeah, the basic facts about this case is that there's a homeowner who had water damage from a storm. The water entered a basement through a window. Hail broke the window, and that added to the water, and that water came in through cracks in the wall. And an insurance adjuster came out to his house and said that the wall paneling of his basement, carpet, padding, really all needed to be removed, dried, sprayed, and then have new carpet paneling and insulation. And the respondent, professional engineer, came out to visit the site and made a report, and the homeowner claimed that the engineer solely to deny the claim for the insurance company. Read his report and his reply, and in the report, it looked like a proper engineering report that was professionally done. He agreed that water entered the basement on the date of the storm, looked at weather data. He said that he didn't think hail broke the window, and he had some reasons for saying that. There weren't any other signs of hail damage. Direction of the wind and bushes in front of the window didn't lead you to think break the windows. He noted that there was moisture entrance in a comparable garage next to the basement that looked like there had been chronic problems with moisture over time, but agreed that water came in to the basement on the day of the storm, and that kind of ended his report. And all of it seemed very factual to me, and presented, and he didn't necessarily draw any conclusions. I guess that led the insurance company to I didn't see anything there that looked improper or violated any rules or laws about his report, except for the fact that he stamped his report with a Tennessee stamp. Bristol, and the way Rob described to me, Bristol has a line between it that's Virginia. House is in Virginia, actually. So he probably, and he's licensed in Virginia. So he could have stamped it with a Virginia stamp, and that would have been the proper thing to do. He stamped it with his Tennessee stamp. So I would recommend, I was looking for some description about letters, but you just ran through them. I would think of maybe a letter of caution about using the right state stamp on a report is what's appropriate here.
Given his location.
Understood. It's
Yeah.
understandable, and
The fact that he had a license in both states, he wasn't trying to get business he didn't deserve.
right now, yeah, Virginia may look at it on their side and maybe do something more serious, like improper use of stamp. Guy's house is in Virginia, so I would interpret that as the job is in Virginia, and he should have used a Virginia stamp on the report.
The house in question's in Virginia. The
Right.
resident of the respondent is Tennessee, isn't it?
Yeah, but the job is in Virginia.
So it could have been next door.
Yeah.
Yeah, because in Bristol, Tennessee is,
Yeah.
you may not know exactly if you're in Tennessee or Virginia, you know, where you are if you don't. I mean, so.
If a letter of caution is, I want to make sure that's light enough. I mean, that I think it was a very mistake. But the point of it is, I think I didn't see anything wrong with his report, and anything that is a base.
Good job.
Trying. Do I have a motion?
So moved, based on his recommendation.
Second. Second.
All in favor?
Aye.
Opposed? Motion carries.
Right, the next heading is new cases, of which there's 2. Six is case number 2013-008641. The complaint alleges the respondent, a licensed engineer, committed misconduct through the use of another registrant seal and failed to properly protect the safety, health, and welfare of the public in violation of our rules of proper conduct. Specifically, the allegations relate to the unauthorized use of another registrant seal for documents in jurisdictions in which the respondent is not licensed. The allegations also include the unauthorized use of a notary seal relative to business documents. The respondent admits these allegations and agrees to comply with the board's disciplinary action. There's no complaint history for this respondent. So after reading the complaint materials, my recommendation is to authorize a formal hearing with authority to settle with a consent order for a 6-month suspension, automatically terminated upon the expiration of 6 months, and a requirement to take and pass the board's law and rules examination.
Do I have a motion?
So moved.
Do I have a second?
Second.
All in favor?
I
Aye.
have a curiosity
excuse
question.
me.
What about the person that let this guy use his seal? Or did he steal it, or how did he get somebody else's?
He worked for this company, and I've worked for engineering firms too, and many times everybody's seal is in a central location. You don't really think your own employees are going to misuse them. I thought about that too.
Any other comments? Questions? All in favor?
Aye.
Opposed? Motion carries.
Okay, the last case, number 7, 2013-012991. This one just is a... This complaint alleges a respondent, a licensed engineer, committed misconduct through being formally disciplined in another jurisdiction in violation of our misconduct rule. Specifically, the respondent's registration was suspended in one jurisdiction by being placed on 5-year probation. While this probation was effective, another jurisdiction found that the respondent's practice within its own borders did not comply with its minimum standards and imposed a civil penalty due to the fact that the respondent was already on probation in the originating jurisdiction. This formal discipline resulted in the originating jurisdiction demanding a review of the subsequent formal discipline. The respondent was unable to participate in the hearing and was subsequently revoked, which the respondent is appealing. Because of all this, a third jurisdiction imposed a civil penalty and suspended the respondent for 2 years effective July 10th of this year. There's no complaint history in Tennessee for this respondent. The respondent asked, because of his business, that the action taken by Tennessee be limited to the extent of the respondent's remaining suspensions. So, it's unlikely that we're going to be the last state. So the recommendation is to authorize a formal hearing with authority to settle with a consent order for suspension to expire upon the successful completion of all mandated disciplinary actions in the jurisdictions where suspension remains effective, and a requirement to take and pass the board's law and rules examination.
Comments to this? Do I have a recommendation?
Got a question. So there's, if I'm understanding it right, there are three, right now there are three jurisdictions in that this respondent is dealing with, and the first jurisdiction he's appealing theirs.
They revoked him.
Yep. And then
the second,
right, and we don't know if there are going to be any other jurisdictions that are going to jump on the bandwagon.
No, there probably will be, but we need to base our discipline on what's already happened. First jurisdiction revoked, he's appealing. Second jurisdiction was a fairly large civil penalty for what they considered misconduct. Third jurisdiction put him on probation for 2 years. So right now he's on probation for 2 years. It started tolling July 10th, last month. He's appealing his revocation, and he's asking that we, if we do anything, suspend him, just be as lenient as we can. The thing that I was suggested to the board is that we suspend him until his suspensions expire.
That include any future jurisdictions?
No, it'd be just the ones that we know about.
Do we know what the misconduct was?
Well,
Can you discuss
it all started with he expired, didn't renew in time, and got sideways somehow with the first jurisdiction. It took some action against him. They suspended him for a while and did some other things to him. But while that was going on, he was doing some work in another jurisdiction and did something they didn't like. Found out that he was on probation in the first jurisdiction, and then really didn't like that. The first jurisdiction found out about that and wanted to see what happened. They called him in for a hearing. He couldn't show up for some reason, and they revoked him. The third jurisdiction suspended him for 2 years.
But do you know why the second state had a problem with him? What the problem was? Was it a health?
For us, it wouldn't be that bad. It would be, there's levels of competency without being completely incompetent. And they apparently didn't like some things he did, but then they found out that he was on probation somewhere else, and that aggravated their penalty. That attracted the attention of the first jurisdiction, his home jurisdiction. Not a native of Tennessee.
Is license in good standing in Tennessee right now? Okay.
Any other discussion? All in favor say aye.
Aye.
All opposed say no. Motion carries.
Right. That's it for that.
Now we go back up to consent agenda.
Chick, our litigator, would like to present his formal hearing update at this time, if that would be acceptable.
Well, if we're going to move, I guess, the professional society report, he can go. Go ahead.
Good afternoon. There's a case that was set, that is currently set for hearing December 5th of this year against Frank Alexander Clayton, who is a engineer. He resides in Florida, but the original allegations were that he had affixed his seal to some stamps that were started by an unregistered person. His response generally was that he had reviewed that and made changes to it, but notwithstanding that, we filed the notice of hearing and charges. There was a consent order offered at some point, which he declined. We went through the process of retaining an expert who did extensive review of the case, and we have a proposal to present to the board today, and I've got some copies. I apologize, I did not make 12 copies. I forgot how many members of this board there are. I've got 6 though, so if you don't mind sharing. Pass them down. And as you'll notice in this agreed order, generally the agreement would be that he take the law and rules exam before he resumes any practice in Tennessee, that he pay a nominal $100 penalty, and that he pay the administrative cost of $200, and that he reimburse the state for $3,350 that would be paid towards expert fee reimbursement. So that's the terms of the order. It's considering the case is 7 years old, and there was some delay in bringing the complaint, I think, which he alleges encouraged some notes that he had made to be misplaced. But all in all, I think it's a pretty fair resolution that I would present to you for your consideration.
I move we adopt the recommendation.
A second. I second.
Any discussion?
Question, Adrian.
Yes, sir.
Has he agreed to this?
Yes, sir. He has signed this agreed order.
Okay, he has. I'm sorry.
As you can see, yes, sir.
Okay, I'm sorry. Never mind. Okay.
Any other questions?
Did I hear that you require him to take law and rule, pass a law and rule test?
That's. I don't think he's practicing right now, but that is a requirement that prior to engaging in conduct here, that he'll retake it.
How do we ensure that that will happen? The board staff will make it happen. John Young will make it happen. This individual thing. How do we flag in the file? How do you know that? He,
Flag the file?
yeah, that he would have to take and pass a law and rule test.
But if he resumes practicing in Tennessee, that's what I've got written in here, if that's acceptable.
But how would you know the staff?
Make a note in our database.
Okay.
Flag it, yeah.
Thank you.
Okay, and I have a final order that just one copy that I can present to the.
Let's have a vote, please. All in favor?
Aye.
Opposed? Okay, now I can say.
Now he can.
No, we had questions.
Hey, Adrian. Come.
And we've got some other cases that are in the works for some contracts. That tends to be the delay is getting these contracts.
You don't foresee anything in December, then it's probably more.
Probably not. Because all the ones I've got are.
Expired.
Expired.
We're done.
We want to go back to, let's just go on with the agenda, consent agenda. That'll go
Okay.
pretty quick.
On page 85, you have minutes from the June meeting. Up to you previously for your review, which you may now adopt if you so.
Has everybody reviewed the minutes?
I move we approve the minutes of the June 12th, 2013 A&E Board meeting.
Do I have a second?
Second.
Any other discussions? All in favor say aye.
Aye.
Opposed, say no. It passes. Next.
On page 91 on your iPads are the complaints for board decision. These are complaints in which the respondent was disciplined in another jurisdiction. The discipline was less than a suspension or revocation, so in accordance with board policy, we issued a letter of caution and recommend closure.
Do I have a second?
Second.
All in favor say aye.
Aye.
Opposed? Motion carries. And now we are into Candy's report, professional society reports.
Tennessee Society of Professional Engineers. I have a request. Would it be possible to put the page number for these things that you have on your agenda on the agenda? It might be complicated because you add things to the material later. And I'd also like to officially request that I get a copy of the legal report that Rob presented today.
Normally do that, I just neglected to this time. I'll delegate that to Wanda to make copies of all such future things. Oh, very good. She's ahead of me.
I just wanted to officially, that would be helpful, especially the one related to the rules and qualifications-based selection. Okay. A couple of things. Our annual meeting is coming up on April 12th and 13th in Murfreesboro, and
April, not April.
I'm sorry. September. Yeah, the other April. No. And John is going to be there to present, and I don't know who else has committed to come with you, but...
I'll only come if I get a paginated agenda for that meeting. Yes.
And...
and Hal scheduled. Yes, yeah.
Decided that at
You
the
were
last
nominated
meeting.
at the last
Okay,
meeting.
Great.
You didn't show up. We nominated.
And the rest of you could come too. And we are having an open forum for students. There will be students there on Friday, so it's an opportunity for them to talk to you. Okay.
Refreshments provided,
Yes, there will be refreshments, Hal.
libations too.
No, not on Friday afternoon. We want them to stay awake while you're presenting.
Oh, ouch.
Yes.
Okay.
And we will again have an Engineering Excellence Awards program, which you've heard me talk about before. I have been working, and a representative of Parsons Brinkerhoff has been working on a project on the underground utility damage prevention to come up with legislation for next year. Ricky knows a little bit about it, and some of the rest of you may too. Apparently the federal government has put a carrot in front of us now to say you really need to change your laws on to work on preventing damage to underground utilities. People like Paul Deggs are on the committee, and Tom Roberts representing the engineers. The road builders are on there. The contractors are on there. The stakeholder and Piedmont Natural Gas. The stakeholders are numerous. We're working through the state architect's office on quality in construction and different types of delivery methods, and doing a follow-up on after a project has been done to see if it really worked out the way it was supposed to. We're working with the state fire marshal on the issue of the residential code, specifically in Memphis, which was a result of legislation that was passed last year. Fire marshal had a meeting in July. The next one is not scheduled, but we are focusing only on the residential, not on the commercial. So I wouldn't be surprised if legislation didn't come next year addressing attempting to exempt or give local governments the opportunity to exempt themselves from the seismic requirements for commercial buildings. NSPE has adopted at its meeting in July 2 particular policies. One of them,
again, about the seismic.
Legislation was introduced earlier this year by folks who wanted to allow local governments to adopt codes that were less restrictive than the state code. They were getting at seismic. They didn't actually mention seismic in the legislation. And the state fire marshal agreed to have a conversation with stakeholders on that subject to see if there is a way to address that for residential. Does that answer your question?
In other words, lessen seismic requirements for residential only.
I do not pretend to understand anything about codes, but apparently the International Residential Code is very prescriptive. I mean, it says this is what you must do, and there are no ways to work, to make alternative things available to a homeowner. And so they're attempting to include amendments that would allow, if you do this, then you don't have to do this, that kind of thing. I'm not articulating that very well, but
I get
you get it.
I get
Okay.
the understanding.
Okay. A position taken or policy adopted by NSPE relates to allowing people the flexibility to take the PE exam before they've met the experience requirements, but they do have to have met the educational requirements for licensure. And then one related to the licensure of returning veterans and military spouses. And basically it says, I mean, it's a whole page long, I'm not going to read it to you, but it says expedite. They have to meet all the basic requirements if somebody has been assigned out of the country for 180 days or more. And there's one last thing, and that is that Connie Wallace is not here because they are having their statewide meeting down at the new Music City Center. And she is retiring effective September 30th. I believe she mentioned that the last time. Maybe she was here. I don't know. But she has a good excuse for not being here today. And I'm going to be one of the roasters at a dinner on Friday night. So if anybody has a good Connie Wallace story they want to share with me, I'd love to hear it. And that's all. Any questions?
What was the position of the two engineering society about the NSPA PE position about taking the PE exam anytime? Do you have any?
It was
position?
just the National Society of Professional Engineers that adopted that policy. The Tennessee Society has not acted on it, and they probably wouldn't since it's a national policy, and ACEC has not considered it. They consider that more the domain of the National Society or the Tennessee Society.
But along with those, and I think Philip's going to bring this up in his engineering report, that's something that we as a board are in favor of we've got to get through some of the details of the reference and the time and stuff, and we'd be very interested if you can ask the TSP board or whoever pitfalls they may see that we're not, because I think it's October. We're going to talk about it some more at the retreat in October, and I know that may be, well, that's a couple months, but I mean, if we could get just some talking points or something so that we can make sure that we've got everything in order, because I think generally we're in favor. We just want to make sure that we don't open up a gap or something that we don't.
Okay. The pitfalls of expedited licensure of military.
Or problems they may see. You know, we think there's some issues, but we've not talked about enough to.
I think all along that we all agree the reason why they have 4 years is because some of the question in there are design question, like requiring you to know the code book. So for a guy who just get out of school to take the exam, they may have a problem passing the section of the code section.
Okay, I misunderstood Robert's question. If he was,
we're talking about
two separate issues.
Well, yeah, but it is. But we are in favor of taking the PE test right after you take the FE, and then getting 4 years of experience before you become licensed.
Allowing somebody to do that.
Yes, sir. Allowing them. We want to understand. We've got a really good set of documentation from the NCAAS folks as well as NSPE on some pros and cons, but I would like a Tennessee perspective on that as well, so that we make sure that there's nothing out there that we're maybe overlooking as we go through that process or procedure that we.
You're not talking about military personnel.
No.
You're just talking about taking the exam
Yes,
early.
ma'am.
Okay.
Because I think we've already got kind of an expedited process here in Tennessee for the veterans.
I think you do too.
So
I was just
that
reporting what
wasn't-
NSPE
yeah.
had done.
Yeah.
Taking the exam early, they still wouldn't be registered until they had their 4 years
Oh.
of experience.
Questions? Thank you.
One other question. Who's going to be our state architect?
Well, I was late to come down here for your hearing because I was in a meeting with the state architect and some other folks, including representatives of the constitutional officers. And I don't know. We were talking about how the job description should be, and, you know, it's early yet. It's going to take a little while.
On you're up. Director's report.
All right, before we get into the attachments that are not paginated on your agenda, sorry. National Council meetings, Rick Thompson, Jerry Headley, Frank Waxter, and I attended the NCARB annual meeting in San Diego in June. You have a report later on the agenda on that meeting. Hal Bothrop, Ricky Bursai, Rob, and I will attend the NCAAS annual meeting in San Antonio, Texas next week. Bill Lockwood and I have been approved to attend the CLARB annual meeting in Minneapolis on September 26th to the 28th, and upon receipt of additional information, I'll submit a request for Susan Ballard and myself to attend the CIDQ annual meeting in Las Vegas, Nevada on November 8th and 9th.
Can I go to?
Yes.
You can go in my place.
Those are our upcoming National Council meetings. Other meetings, as Candy mentioned, Hal and I are scheduled to speak at the TSPE, ACEC, ASCE.
But to what group are we speaking?
Come up with our topics and that we want to cover. And you had some suggestions, yeah.
Immediately before your presentation, and John chose to go this way, the ASCE is having somebody talk about raising the bar. You know, increasing the registration requirements.
B30? Okay, so we don't need to reveal that we voted against it before.
No. No. And they now call it, ASCE now calls it raising the bar.
Yeah, we all know that that's rapidly off in every state. No, sorry. only one state's ever has tried it so far. I think it was Nebraska, if I remember correctly. And they failed miserably, and it's never come up again. administrative issues. The Spring Summer Design Lines newsletter was distributed last month to about 18,000 recipients. All of the grant contracts for last fiscal year have been approved, and funds have been distributed to the schools. Letters have also been sent to the various schools, both public and private, notifying them that $300,000 of grants are available this fiscal year and requesting that they submit proposals by October the 1st. So we'll have those to review at the October meeting in Cookeville. And also have notified registrants via the newsletter and local officials about the new rule about competitive restriction on competitive bidding on local public works projects. Our reports are on. I'll have financial information for you. This is not working. At the October meeting for your review. That will include all of fiscal year 2013, including our cost back numbers, how the year closed. We'll have that information for the October meeting. Let's see here.
I think it starts on 97.
Thank you. 97. You have licensing information, the number of registrants, applications reviewed and approved following that, and then complaint data begins on page 99. This is all just for your information, does not require any action. You have a list of open complaints on page 99, and this is just a snapshot in time showing you where we were at this point with all of the open complaints. And you'll see that as far as our metrics go, a percent on time within the last 180 days, last 18 months is 98.75%. That is where the clock was stopped on those complaints within that 180-day time frame, meaning that the case was closed or a consent order was issued or formal hearing was authorized, something that would stop the clock, as we say.
Civil penalties brought into your budget, or did
that goes into general fund? Yeah, that's my understanding. And you have the civil penalty information as well as cases open, closed, etc. by quarter. So that concludes my director's report. Unless y'all have
we
some
really
questions.
only have about 10 to 12 cases, potentially. We got rid of one today, the 2007 one.
Right.
And then there's formal ALJs, but we don't hear those.
Right.
So the ones that have formal, that don't have anything like letter of cause or anything, there's only about 10 to 12, correct? Something in that neighborhood. That's pretty
Well,
good.
it's really 9 at this point, because assuming that the ones that Rob will send consent orders to that have been approved at this meeting sign the consent orders. Hopefully they will, and then it won't go to a formal. Yeah. So slowly whittling down the number, right?
engineer committee report? Wednesday, that's what I want to know.
The engineer committee met this morning at 9 o'clock, and we have a new member to our committee. It's Laura Ryan Bolt. Is that how you? Okay, I want to make sure I get it correct. And the names, but I think the things that is noteworthy for this group to pay attention to is we as a committee, if you turn to your iPad on page 66, talk about what do you do in the event when you have a registrant or applicant that comes in and say that they could not get a official transcript from a school. Like, for example, somebody may have left the country due to political reason, or maybe, but they have the origin. So we have some kind of waiver policy that we as a engineering committee has kind of adopted, and we'd like to present it to the board for consideration. I believe that this will benefit all the profession in this board here. We have cases where, you know, some guy who left the country and he could not go back there because of political reason, or maybe the school that he used to go to no longer there anymore. So what do you do in that kind of cases? So we felt like we should adopt some kind of policy, and John Cartron was the one who brought it up to our attention, and I think recently the engineering committee had to deal with. We felt like adopting this policy would be good for the committee. We want to bring it up to the board. Let you all consider that. Is that the way we present?
Yeah, I mean, that's right. And part of it was we have a lady who has, her university doesn't exist anymore. The United States blew it up in a friendly fire accident or something. I don't know exactly. It's gone. I don't know. It's probably one of those videos that you used to see on the Desert Storm thing where they would come in every night and say, look, we blew this up. So anyway, it's gone. And she couldn't get an official transcript, and I suspect there are other instances like that, more out of country than in country, but that may happen in. But the good guys in, the bad guys keep them out.
What's your what have you thought of as a means of substitution?
Basically, if you got instead of having the institution have to send the transcript, if they've got their transcript and their diploma with them, and then there's a couple affidavits and some other. But the policy gives us some flexibility to evaluate on a case-by-case basis, and we may require more information, but it doesn't just cut the line off and say we can't ever consider that. Which, I mean, that's, you know, it's not their fault that their university got blown up.
Under the present situation, I think we consider as a board or the committee, I know for engineering, we consider on a case-by-case basis. This policy set in stone for us that this is what we're going to do going forward. So that
they have to exhibit an extreme, let me say it this way, extreme hardship in trying to obtain a official transcript from their graduating university.
Mm-hmm.
I think John wisely put some information about destroyed and some other things, because he's had situations that, you know, the school was just tardy in getting information to him. Well, that's not a hardship, you know. But the school's not there anymore. That's it probably won't impact the architects as much because you probably don't have as many out of country applicants.
Other than just the committee accept it as a policy, we thought maybe we should just bring it for it.
Incorporated across all the groups.
Board policy. That's the recommendation for engineering committee. Yes.
So do I still need to have a second on the recommendation?
No, this committee stand is a second.
So we just need to vote on it. Any other discussions on this matter, given the flexibility that it's allowing? All
apply for both engineering and architectural and landscape and
everybody on the board. Yeah.
We're not voting on a specific recommendation yet. Is that what you're saying? And we're going to talk about it at the retreat, or
this one?
No. This the committee is bringing up as.
Is this the
recommendation
to
adopt this policy,
make it official transcript waiver policy?
Right.
Okay.
To make it official for us.
Okay.
All in favor, say aye.
Aye.
Those opposed, say.
Okay. The second thing that I think would be for engineering committee, as you all know, Hal and Ricky is going to the NCWES meeting. One of the things that we'll support in favor of is to support what NSPE has position statement allowing people to take the PE exam after their graduation, but yet we as a committee felt like we should discuss more in the retreat to iron out any issue. And prior to my report, as you all know, that Candy is going to poll her professional group to see anything concern they may have. So that's kind of for your information. And then also the grant money has been given out, as John has said that. So, but that's pretty much in general that we talk about. Now we have other fun things we discuss, but I think these are the things I think the board needs to know.
Okay. Anything else?
No, that's all.
Unfinished business, action items?
Items are on page, oops. Who's got their page number? 103, thank you. I did send that information to Candy, list of interns and exam applicants. Of course, Hal and I will be participating in their open forum. And Rick mentioned earlier when he did his report, making his recommendation that he's going to work on a newsletter article dealing with qualifications-based selection, possibly for publication later this year.
This is a question. Actually, Kenny is here. Maybe she can help me. Kenny, there was some question going around about the PE review exam. There is another organization that is going around too. Would you mind enlightening us? What is that? I've been trying to promote the one that TSPE has been sent out.
I think it's the PE school or School of PE, and it's happening in Memphis, I know. We only had 3 people sign up to take our review course from Memphis, but we have a total of 29 people taking the review, which is a lot more than we've ever had. And we've got Knoxville, Chattanooga, Jackson, Nashville, and Memphis.
The PE one is like 3 hours a night for 4 nights a week for 6 weeks. It's a webinar though, as well. I mean, so there are some that, and they're touting their success rate in passing the PE. And so I know of 1 or 2.
It's civil only. Because I saw what was in the newsletter.
It's only
for
civil.
ACET, and it looked like if you were electrical, that you had to go watch some Minnesota webinar.
Right.
Okay.
It's just civil.
So this one, just civil here in Tennessee. Okay.
How many students what's the minimum number of registrants to hold a class?
Last year, I think it was 7 or 8.
If disciplines want to have a class, they have to generate an interest in.
We have tried to have a mechanical class, and before we had trouble generating interest in Knoxville to take a civil class. There's just not that many people who are interested in a review class. Is that what it is? Maybe that's
Robert tells me.
But the biggest question, I guess not concern or question, is just that as much as we send these people interested in taking the PE review courses to Candice, because Candice represents TSPE and ACEC. What happened if the school or PE comes along and says, can we give us the list of name? Are we obligated to do that too?
They can pay for it, but yeah.
It's a public record.
Public record.
Okay, that's what I want to clear up. Because I got a lot of questions. As you know, I was in Memphis, and I was pretty much surprised that somebody would compete with TSPE. So.
I'm surprised too, Philip.
A lot of money in that business, I'm telling you.
If the allowance to take the PE early gains traction and Tennessee adopts that as an allowable method, it's
And the more important question for you is how many of them will pass the exam if they don't have that 4 years of experience?
Not going to be easy.
Is that all the action items, comments, new business?
Thank you, Candice.
Resolution for Alton Heathcote. Have you got that?
Yeah, we do actually have a resolution.
We call him AKA Alfred Hitchcock.
And do we?
Yeah, that's all we know.
Okay. Back. Basically, this is a State of Tennessee State Board of Architectural and Engineering Examiners, a resolution of gratitude for the service of L. Alton Heathcote the second, P.E. We, the members of the Tennessee State Board of Architecture and Engineering Examiners, do hereby certify that L. Alton Heathcote the second, P.E., served the state of Tennessee and an engineering profession unselfishly as an associate engineer member of the board from September 28, 2009 to July 28, 2013. Whereas he is a person of honor, dedication, and integrity, and demonstrates these qualities both in his professional and personal life, and whereas he made significant contributions to the mission of protecting the health, safety, and welfare of the citizens of the state of Tennessee through his active participation on the board, and made sound, fair, and impartial decisions, and further enhanced the many related laws, rules, and policies of the board, and whereas he could always be counted upon to offer thoughtful and insightful comments and recommendations, and never shied away from spirited discussion, but was always collaborative and mutually respectful toward others, even those of differing views. And whereas he demonstrated loyalty and diligence to the board, our applicants, our registrants, and treated each with great personal care and respect, whereas his presence during the meetings will be greatly missed and fondly remembered, and whose contributions will have lasting effect, and whereas we wish him well in his future endeavors, now forever be it resolved that L. Alton Heathcote II be commended on his distinguished service to the profession and the state of Tennessee, and his name and contribution not be forgotten. Dated this 14th day of August 2013, Nashville, Tennessee, and signed by the members of the board, except for signature. And we'll present that at our December board meeting.
I make a motion we
So moved.
resolution.
Okay. All in favor, say aye.
Aye.
Opposed?
Only thing I wanted to add was AKA. Hey, can y'all make him a name tag for me, Alfred Hitchcock, so when he come?
Assignments coming up next. I've got one. Definitely, Laura is going to be on the laws and rules and policies, and she can be on that committee. I'd like to also place her on the. Of course, you're on the engineers committee, no question. Is there another committee that you would like to be on?
I don't know how to answer the question. What's the typical obligation?
Grants to higher education. I tell you what, licensure outreach.
Typically, people are on 3 committees.
Well, I'm on like about 6, but I'm only one
I
person.
understand. Yeah. So you want me to choose another one?
Right.
I don't have the list in front of me. I'm sorry. I don't mean to be dense, but I'm
That'd be good.
Let me go away from that.
Continue
one.
education.
Okay.
I mean,
She's on
so
this
being
one.
the secretary,
I'm putting her on this one, and I'll let you come over here.
that might be a good thing since I'm secretary would be on the
I think that would
finance.
be good.
What do you other say?
We're gonna move
Since I'm
Robert.
secretary, wouldn't that be
Yeah, we're gonna move Robert to finance
for Alton?
for Alton's on his
Is
spot.
that right?
Robert's going to finance.
Laura's in law and rules. And then basically maybe add Laura to the publications, building manual.
continuing it.
Okay.
Education would be good for us.
Okay.
Oh, Bill, actually, the bylaws state that the secretary is chair of the Finance Committee. So,
That's what I thought I had to be on the finance.
yeah,
committee.
Mr. Campbell will actually be the
So you'll be the chair.
chair of
the
that
chair.
committee.
Rick going to stay on it then?
You just want Rick to stay on.
Rick is vice chair, isn't he?
Yeah.
He can stay on, isn't he?
Is chair.
Artist committee.
That's what I thought I had to go to.
Yeah, Hal and I used to work hard on it.
Well, y'all just republish the committees then
Yeah.
send to us.
And then Laura will be on the continuing education. Does anybody else want to move?
I got a question about, I'd like to, because I've been the chair for the engineering committee the last couple of years, is there a way is that among ourselves we can, like somebody else to be the chair rather than me be the chair?
Yes.
Right here, or do we decide among the committee? The chair?
Lockwood can actually appoint someone as chair.
Y'all have a preference who wants to be the chair?
It's either between Hal or Robert. Since Robert is the chair for the finance committee,
Hal could be the
how are we
chair
going to
for
be
the-
the chair for engineering committee?
Sure you want to do that?
Asking me or them? I know who you're asking. You're asking
But I'll still
them.
be on the committee.
Yeah.
We're going to be, we'll zip through quickly.
Bill, and you can add me publications
Okay.
committee. I talked to Sue.
Thanks, Hal. So I can be late for the meeting now.
Phone in. You can phone in.
Bill, since Alton's not with us on the grants committee, do you want to name a new chair?
Susan?
It'll take me off publications, I will.
Yeah,
No.
I'm serious.
you have to.
No, just off the chair of the committee. I'll stay on the committee.
Stay on the committee.
I'll stay on the
Okay.
committee. I'll do chair of grants.
Okay. Stephen, where's Steve? How about it? You take the chair?
Susan going somewhere?
She's going to be the chair of the
Grants.
grants and higher education. But what would you like to?
I'm just gonna wait for Wanda to publish a whole new deal. I lost track of who's moving.
Yeah, let's
where.
go through it here. Make sure we got
I'm just
everybody.
waiting.
Unless you want to make any changes.
Get my.
More
I think we're
Okay.
Engineer, you're going to
Hal Balthrop will
Hal
be
Balfour
chair.
will be the chair.
Okay.
Can I move the architect committee by any chance?
And I'm on that. If you didn't have that.
Laura's on the meeting. Grants to higher education, Susan's going to be the chair. The rest of the members stay. Laws and rules, Laura will be on that committee instead of Alton. Publications, Robert's going to move over to finance as the chair, and then Rick Thompson will become the chair for the publications, and then Ricky will be on that committee. I'm sorry, Steve
Oh,
King.
Steve
I'm
King's
sorry,
the
Steve
chair.
King is the chair.
And then,
Just to mess you up.
Say that it's Steve is going to be chair?
Right.
Okay.
what are we going to do with Wilson? He's not on any committee.
I'm on all kind of committees. Speak
surprised
for
he's
yourself, fella.
I want to make sure you're busy. Now. I don't want you to feel left out.
License outreach is staying the same. Nominations is staying the same.
Nomination, Rick was the chair, so he's still going to be the chair. Yeah.
I think for this,
Wilson would be a great chair for nomination. Nomination.
I think for this time he will stay chair.
You want to do
Let's
that?
put Wilson
Finance.
on the
Wilson.
nomination for chair.
For chair.
Okay.
Rick on there or
Yes.
take him off? Okay.
Thank you, Wilson.
You gonna stay on there? You gonna on nomination?
I'll stay on nomination. I think license outreach. Is there someone else that might want to be the? You want to do that?
No,
as chair?
not me.
I thought you said.
No, I want to bring it up. The reason why I was in the nomination committee because I was the chair for the engineer committee. I think appropriate for Hal to be on the nomination because he's the chair, right?
I'll be glad to help.
Doesn't matter. I'll stay there. I'll stay there.
Oh, I see what you're doing.
Yeah.
I'm a little slow.
I'll stay.
You need to stay.
You need to stay on this time.
I'll stay on.
Okay,
I'll be glad to relinquish the continuing ed chair if you would like, or someone else. I'll do it unless if someone else would like to do it, I'll be glad to relinquish that if anyone wants to do it.
Or just join.
I think is that good for everybody? Everybody comfortable with those? Any other changes?
Do you want to volunteer?
On Hal didn't want to be continuing
I will
education chair.
unless someone else would like to do it.
I'll chair if you need me to.
Let Frank chair the continuing education.
Hadn't been to one of the meetings yet, but
how are you
I
still
missed
gonna
last
Now
week's
that
meeting.
means you'll have to show up.
Yeah.
how are you still being a continuing education?
As far as I know it, I never met.
Okay.
I don't think it's ever met except at the retreat.
I know.
That's right.
I know.
Just one time a year.
Guess I'll find out.
Made some
Had some other
additions to
meetings
the
before, but
forms and
outside the
stuff.
retreat, but it's
We
rare.
did.
Hey, but you did.
We did.
Since you're the chair,
All the
we'll
work.
probably have several meetings.
Oh, yeah.
during
yeah.
the-
The first one will be in San Antonio next month.
Thank you, sir.
Okay,
Everything's
next on the
paid
agenda, October meeting agenda.
Okay, that's right behind the committee assignment chart, page
105.
105. You have a draft of the agenda for October. A few issues to bring to your attention. We're still working on nailing down the hotel. We do know there's a Marriott Fairfield Inn and Suites that has availability with
Holiday
free
Inn.
parking, Wi-Fi, and continental breakfast.
There's a Holiday Inn there too.
Yeah, there's several hotels in Cookeville, and I think, who was it that recommended one to us? Mr. King? That was for Cookeville. Oh. all right.
I'm very familiar with. They got a Holiday Inn there. They
Yeah,
got
there's a
Claymore.
Holiday Inn too.
I know the owners of the Fairfield.
Oh, you do?
Yeah, they're
Okay.
my clients.
Okay. I think it's one of the newest
We
hotels
need to stay
in
there
Cookeville.
then,
That's why I thought it would be good.
If they're
Yeah.
available.
Yeah, they do have breakfast.
It's so new. Yeah.
Have you already redone that one? Have you redone that hotel?
No, they had a new property maybe 2 years ago. So
Not due yet. We could trash it and then they would. We'll go rock star on it.
There's a Holiday Inn there. I tell you, I stay there.
I don't think we should stay anywhere that Mr. Lim recommends because he's very frugal. No, I'm just kidding.
We could go Bob Campbell and stay in the old quad beside across from the library. I think there's a girls' dorm.
Yeah,
there now.
Susan's place or the Thunderbird.
Hey, it's Susan's.
All right, yeah. That's where we were thinking of.
I know good
the
restaurants in
Fairfield.
Cookeville too.
Oh, good, because we'll get to that.
I do.
On the
Dad, when he was there, was over in the quad.
On the committees for interior design, landscape architecture, architecture engineering, you'll notice we have wall certificate design on there. Susan asked me about that. We haven't discussed that in several years. Right now, we have...
Did Hastings ever make the change?
No, that was the board seal.
Oh, okay.
This is the wall certificate that everybody gets that they like to frame on their wall after they're first registered. It's kind of an odd size and sort of a dated design. So we were wondering if there might be a desire to look at that to see if we want to update it, maybe adopt a more standard size, a smaller size that might not require a large format printer in order to print those.
What size can you accommodate?
Well, right now it's 11 by 15. We would like to make it maybe like a legal size, perhaps, or
8 by 14?
11 by
8.5 by 11.
17's a
Yeah,
ledger.
11 by 17.
It's a ledger size.
Yeah,
Yeah.
ledger size.
frame size would be 11 by 14. So
But the ledger
That's 11.
size?
That's 11 by
17, and you
Okay.
can do that.
Yeah, those we can print just on our standard printer. Our
Vote on it
copier, I
today.
should
Do
say.
y'all have any objection? Anybody? I mean,
Might want to revise the other
Look at it,
aspects
yeah.
of the design, too. I don't know.
Oh, you don't you don't fool around with that part. You can change the size of the paper, but you don't fool around with that.
Oh, okay. All right.
If it isn't broke, don't fix it.
Want us to do that, to switch the size to 11 by 17 then? Yeah.
There's one thing in life, after going through the process of getting the thing, I like to see what the original one looks like. And, when you start changing the graphics, I've got some from other states, and they're just plain Jane. But that I like, it's nice to look at. It reflects the blood, sweat, and tears that I went through on that design, the 8-hour design exam.
My Tennessee certificate that I got in '77 was done with a Leroy pen. It's not formal looking at all.
Neat and individualized, though. That's neat. You don't like it, or you?
It kind of stands out among other.
You don't think it looks?
Like,
don't like it?
I've seen those.
No, I didn't care for it. No.
Oh, really? Oh, okay.
It's really clean.
Is it?
We
Oh,
can-
I see what.
We can
Wasn't even
discuss
somebody
it
that
further.
could handle
It wasn't special. I'm sorry. I thought it was.
Maybe, John, go ahead and print one out
Yeah,
at 11 by
that's what I thought. Yeah,
17, and then we can kind of then look at it.
compare and
And
see what they
then
look
we
like.
can go
Right.
bring it up
Get a
under
new
the
one,
wall
Frank.
certificate thing at it. Yeah.
Right.
Frank,
I'll keep it on. I just
you
didn't
can
know if
get
you
a
want,
new
if I
one
even
issued.
needed to keep it on there or not. Okay, then we got dinner Wednesday night and also dinner on Thursday night. So you might want to be thinking of places that we could go.
Oh, you mean Bubba's?
Also for lunch on Thursday, I didn't know if you might want to do something off-site or if you would prefer to have something catered at the meeting facility. Whichever I'm not sure what the school is going to provide, if anything. Yeah, right. We're on campus at Tennessee Tech. Yeah.
I just noticed this continuing education committee meets at 8 a.m.
Now you know why we call it. Now you know why we
early, aren't we?
Yeah, I found it.
Yeah. Well, we got a lot to cram in. So. I'm not really sure that committee will even need to meet or not, because right now I don't know of any rule changes that need to be considered. As we get closer to the meeting, whether we need it or not, you can make that call.
John, typically even, I know this committee, each committee member needs to try to be at a meeting, but the last few years, we were all there the whole time. It's just about everybody was there.
Especially when we were at UT in that closet.
Yeah, it's sort of like the whole thing's really a board meeting, isn't it?
Right.
Yeah.
So there's a reason why we kept it small so the committee can discuss. I'm not trying to discourage people from attending, but I just think that we just need to respect the smaller group for them to discuss.
We actually just have one room reserved for this, because you'll notice we don't have any of the committees meeting consecutively at the same, or not simultaneously, I mean at the same time. We've tried that in the past, but it hasn't worked too well.
What is our latitude to use? Have you got to up it up again?
Oh, the grants?
Yes.
I wouldn't advise it until we know how that's going to impact our bottom line. And
I mean, could we tentatively make recommendation that, depending
Problem is, we can't spend directly from the reserves, which is something right now we can't actually use the reserve funds. We have to draw from our revenue. There's no mechanism to actually spend directly from the reserves. Fiscal year 2015, probably towards the end of this year. Yeah.
I was the one that pushed it last year. I will.
Ideas about lunch? Do y'all have any preference on that? Just
Thursday?
Whatever tech lets us
Have a
do.
box lunch brought in or something?
Yeah.
They have food service there. Look at us. You can tell we didn't miss a meal.
They're alive. Let's put it that way.
Mousetrap's still not in business, is it?
It's called something else now. But there's a grill in the university center, and there's a
All campuses
cafeteria.
have culinary, classes now and can do things. So, okay.
At home ec there.
I don't think culinary and tech go together very good.
Question it all over the, media. So, anyway, okay.
Y'all have any agenda topics to add? Of course, just pass that along to me. I've already gotten some from the engineers to add to it. So, no, not for this year. We do the meeting with all the deans every 2 years. Of course, the engineers, we met with them in April, just the engineering deans. So we have a meeting with all the deans next October.
We'll talk later about the curriculum. Dean Rentz is aware that we're coming.
Yeah.
Okay.
Yeah. You're referring back to what happened at UT? Yeah. Yeah, that's right. Yeah, the engineering school, they didn't have any trouble remembering we were coming. But yeah, they've reserved a room for us. So
14 meeting schedule.
Proposed calendar for 2014 has some other relevant meeting dates on it as well. This follows our current schedule where we're meeting on Wednesday, and then a Thursday is reserved for formal hearings, if any are scheduled. So this is pretty consistent with this year's calendar.
It's the second week of each month.
December's earlier, and October is a little bit earlier maybe. But
That different? I thought you were gonna discuss the.
that's for discussion, right? This follows our current schedule. Now, in previous years, we followed a schedule where the engineer committee would meet on Wednesday afternoon, have a board meeting Thursday morning, which might last a majority of the day potentially, or half the day, and then reserve that Thursday afternoon and Friday for formals, if any are scheduled. Staff, we would prefer, our preference would be to revert back to the older schedule because it sort of breaks the meeting up where it's not such an exhausting day. It gives the engineers more time to discuss because y'all typically have a lot of business, a lot of things to discuss.
Wednesday afternoon and Thursday we have a board meeting, which I like that.
Always the second.
December's an exception because it's, that's generally true. Right.
Answered the question I was going to ask, is what burden is it on the staff? And it sounds like getting all the materials together and stuff.
And I think it would be helpful to the engineers to have, some additional time where you don't feel rushed to end by the time a board meeting starts. But either way, we can work with it.
Yeah. No. I either.
Violation of sunshine.
I did not say we're going to talk about business. I said eat dinner. Mm-hmm.
But if you
What
wanted
do you need to, if we did want to change back to the old schedule, what would be required? Does this committee or does the board
Yeah, because you'll vote to approve the calendar for our board
This will
meetings.
reserve
so-
Wednesday, Thursday. Our meeting will be Wednesday, Thursday, and Friday.
Right.
The dates are the same.
The weeks be the
Yeah,
same.
just adding an additional day.
Yeah.
Right.
Basically, what you'd have is the committees would meet Wednesday afternoon,
Right.
Your committee.
engineer committee. and then you'd
Potentially
have
some others
The board
might too.
meeting Thursday morning.
Yeah,
Right.
9 o'clock. Yeah.
Okay, and then we would have the other day if we had to have formal hearings. Okay. You wanna
Like
make-
that better.
Make that recommendation?
Possible, like the architects, they have to meet occasionally. We might schedule them right before the board meeting some days.
Sometimes they meet
and
after the board
Which would be
meeting.
8 o'clock in the morning,
After.
just
And the
for your
board-
information.
You have the board meeting on Thursday
At 9.
at 9. Are you going to go?
Have that option, but I don't think we've ever
I
done
think
that.
half a day. I
Yeah,
mean, we're
usually half a
doing-
day.
We're doing half a day right now.
And then we might have hearings on Friday, so then you're spending
Thursday.
maybe
We could
2
start on
days.
Thursday afternoon.
Use Thursday afternoon.
Thursday afternoon.
But the likelihood of that has been rare, and
Yeah.
my terms, I mean,
Yeah.
I make a motion, Mr. Chairman, that we have our board meeting on the second week of those month, but starting on Wednesday afternoon for engineer committee meeting, or I just a committee meeting, and then Thursday morning for our board meeting, and reserve Thursday afternoon and Friday morning for a formal hearing.
Do I have a second?
John, isn't it? Go ahead.
And also, the surveyors board, you'll notice I have at the bottom the surveyors board meeting dates. They want to meet with the engineer committee at some point next year. Looks like our April meeting dates are going to coincide, so I'll get with the surveyors board and plan a time
Talking about April the 19th.
period, right, the April
the 10th.
period, when we can have the engineers meet with the surveyors board.
Is that April the 10th? We can do it first thing in the morning, right?
Yeah, everybody in favor of changing the calendar?
All right.
Anybody opposed?
The associate members, they don't really,
My challenge is that every October and every April I'm going to miss for the next year or two. That's that's just something I became aware of now. So it has nothing to do with the Wednesday, Thursday, Friday. That's a
I always miss the June meeting because of a standing.
yeah, and that's
thing.
as long as that's understood. I was not aware of that, so sorry.
in a lot of time, formal hearing, the associate member don't have to stay.
I'm sorry.
For a formal hearing, I think the associate member do not need to stay, right? Do they?
Right, but it's not like the April one's in Hawaii, so I'm not getting back.
Hawaii?
Yeah, I'm not getting back anyway.
Serve all the way back to the
Yeah.
Tennessee River.
Also for the October planning session, which will include a meeting with the deans next year, I think doing that at a state park worked really well last year, so we haven't met at Montgomery Bell in several years. I think that might be a good location for that meeting. October 8th through the 10th.
Dixon, Tennessee.
It's in Middle Tennessee.
It's a nice place.
Very nice.
Yeah, not too far.
Nice place.
It'll be a pretty central location.
Yeah.
Good central location. Because that worked really great, I think, having the deans at Fall Creek
Yeah,
Falls last year.
yeah. I won't go to that. What
It's a good
place we
venue.
went last year, the Fall Creek Falls, that was too far.
Depends on where you are.
Let's meet in Graceland. I would like to.
Elvis is dates, so.
We did Natchez Trace several years ago, so that's too
Pick,
far.
Pickwick was good too.
So you're going to make some contacts to see availability? Okay.
That's a nice venue because we can journal voucher our meals, and it's just real convenient. Yeah, I guess we do. That's it on the calendar.
All right.
So just a point of clarification, so we're going to start the new schedule in October.
Oh, okay. I'm glad you brought that up. I was going to also ask if you wanted to adopt that schedule for the December meeting this year, because those dates, I mean, you can change them whenever you want. It's not totally.
Sounds like,
set in stone.
especially with no hearing on the horizon for December, there'd be no reason not to.
At the December meeting, you'll meet on Wednesday and then
On Wednesday,
Thursday morning.
when? The 4th
Oh,
or
let's
the
see.
11th?
Let me get my
It was
calendar.
going to be on the 4th.
Right.
It'll still be on the 4th, but
It'll be the 4th and 5th.
Right. Yeah, the engineers will meet Wednesday afternoon, December 4th, and then the board meeting will be Thursday morning, the 5th of December.
This year or
It's not
This
on
year.
this calendar.
Oh, I'm sorry. This is
14.
2013.
This is 14 on the thing that.
Yeah, that's right. It is this year. I'm right.
Look at 13.
I'm sorry, I'm confused. Are we talking about December
This year.
2013?
Yes.
2013, yeah.
Are we?
What's that first Wednesday?
The 4th.
So it's the 4th, that the engineering committee will be on Wednesday afternoon. The board meeting will be the 5th
Yeah,
at 9
correct.
a.m. Central Standard
Right.
Time.
Which can be followed by our annual Christmas luncheon. Yes, it could. I'm just...
I roll off
Just
the
bringing
board
that
next
up.
term. Somebody better pick that up. The tradition's been
Well, we're going to put
That's
them
the
come
tradition.
see us at the hotel with free breakfast.
So just back to Laura for a second. Laura, are your standing events the second week of the months? That
No, and I'm sending an email right now. I may be able to.
Okay, so in December, it's the first Wednesday.
It's not. It's only October and April that affects me.
And then February, we meet again.
Right.
And is it the first or second? Well, it's on here.
Second.
I'm sorry. It's the second week. Why did we go to the second week in February?
Well, I
Just
think
out
we
of-
did the December meeting
Are on
earlier,
the
so it
second
would...
week in February.
Because of the Christmas
Yeah.
I'm
lunch.
sorry. Why?
Also
Yeah,
the
I'm asking why.
holidays.
If we're doing the first in December, I'm assuming for the holidays, maybe
Just
or
trying.
something.
Right.
Done and get it behind us.
So, but if
Hal?
Yes, sir.
See, our meeting in February next year, it's actually the second week.
Yes, sir. I may have misspoken. I meant to ask, is there a reason we don't do the first Wednesday of every month? I guess, and I don't know if that's worse for
It's bad for me.
bad for you. Okay.
Bad for a lot of people.
There's some other meeting conflicts, like there's the NCAAS meeting on February 5th.
I think
I try to space them too.
the reason why I think we moved
Conflict with
December
other
because of the
meetings.
holiday and plus
Sure,
of the luncheon.
Sure.
We good to go?
Do we need to make a motion on the December meeting?
Good, probably, yeah. Since you're changing the
For
meeting dates.
2013?
2013, I make a motion 2013 December meeting that we start on Wednesday afternoon for the committee meeting, which is December the 4th, I'm sorry. And then December the 4th, Thursday, we have our regular board meeting, and then reserve the afternoon for our formal hearing, and also followed by a luncheon.
Do I have a second?
Second?
All in favor?
Aye.
Opposed? Motion carries.
So then
On
me-
the record now that it's going to be followed by a luncheon. Thank you, Mr. Lamb. Yes. That was part of your
I'm
motion.
expecting the money
To be
the guy-
followed by a luncheon.
Okay. I'll keep it affordable.
We'll put that in the minutes.
We get the
That's part of
architect's
the
member to
motion.
help find more.
Okay,
It's
report,
accepted by the libations.
NCARB, annual meeting?
Oh, yes, the report on the NCARB annual meeting.
Send it to us.
Yeah.
Okay, we've read it.
Have you read it? It's on page 109. That they are making some major changes to the ARE. It's outlined in the written report. Resolutions were voted on and adopted, and officers were elected. And you have information on future meetings. Any questions?
Okay, nothing required there. Letter of understanding in respect of the manual?
This is something that I just got last week from NCARB. It's related to a resolution that was adopted at the annual meeting in San Diego. It's adopting a new mutual recognition agreement with Canada, the Canadian Architectural Licensing Authorities. And I haven't really read through it too closely until today, actually, during the rulemaking hearing, which was putting me to sleep. So I thought I would read this instead. And so some of the specifics of this, I think we're going to probably need a legal opinion on this because reading the language, it kind of makes it sound like we're just going to have to automatically grant them a license if they have an NCARB certificate, when in fact, we have to look behind the blue cover, so to speak, to make sure they have the right degree, the right...
We could ask for a legal opinion and put this on the October meeting?
Right, I don't think we need to sign it today.
John, are you saying that you're seeing something other than what we had heard at the...
But we didn't, I don't think we had actually seen the letter that was going to be signed by the jurisdictions at that time. Yeah, this letter, paragraph 4 on the first page of the letter of undertaking, this is behind the letter from NCARB urging us to sign it. Towards the bottom of that, the third page, the letter of undertaking, the undersigned will not impose any additional education, experience, or exam requirements, or require education transcripts, experience verification, exam scores, or Social Security, which we require. We collect Social Security numbers to support our state child support program, social insurance numbers. However, the authority may impose familiarity with local laws and other local requirements that a reciprocal licensure. So that paragraph, I think, may be problematic. Yeah, so I believe when we signed the last agreement in '94, we didn't actually sign the standard text. We had to send a letter that basically explained that we can't just automatically license somebody with an NCARB certificate, that they have to meet our minimum requirements. So we may have to draft some similar letter to that one.
Is that a problem for architects? Do you get many applicants that are asking for reciprocity? Engineers do.
What?
And I hate that we do, because I think it's setting us up for some...
Well, what we heard my understanding when this was brought up at NCARB about it, what we do here in the States is different than the way they do it in Canada. I think what Canada is 2,000 hours that they have to work under a licensed architect. And then, once they meet that time frame, then they can be licensed. Am I correct in that, John?
Yeah, what they discovered in comparing the licensing systems in Canada and the U.S. is that they feel that our exam is better than their exam, but their intern experience development program is better than ours. I think was how, or maybe I may be getting that mixed up. But something's not totally comparable. So the way they address that is by requiring that all new licensees, they have to complete a year of experience in their respective countries before they can apply for licensure in another country, in Canada or the U.S. So if
and there was something I think under IDP that we are more stringent, or our IDP is more, they require under their IDP.
But theirs is like more structured or something. There's not as many avenues, I think it was, to get experience.
More structured.
It has to be like under the supervision of a registered architect or something. It's a little more stringent than NCARB's requirements, as I recall. So the way they address that is we're just going to require an extra year experience before they can get a license in our country. But yeah, some of the specific wording on the letter of undertaking, I'm not sure that it really complies with our law and rules. So we'll have to look at it closely. Talk about it in October.
All right. Anything else?
Can we get an updated now rules and book and everything?
You missed the last meeting too, didn't you? I think. Okay. Yeah, we handed some out at the last meeting, but
also the reference manual that was revised 2000.
Been talking about revisions for some time, but
Publication committee. That's something that y'all might take up. Does anybody want to move to adjourn?
So moved.
Do I have a second?
Second.
All in favor?
Aye.
Let's go. Thank you for your time and attention.